to discuss jury instructions. I wanted to just take this opportunity. It seemed to be the best time to take the break to do the jury instruction conference so that we can quickly move through the evidence and instructions and closings once the jury comes back. My clerk has provided an updated version of the jury instructions to the parties today. What I typically do is I go through the instructions up on the screen here. I'll go through each instruction. My clerk will put them up on the screen, and I will invite comments, but silence I interpret as acquiescence to the instructions as presented. So if they're fine, you don't need to say anything unless you have a comment or request something else. So, Madam Clerk, let's put the instructions up. We start with 100. That's a standard instruction. Any issue with 100?
None from the state.
Okay, again, I'll take silence as acquiescence.
Okay, fair enough.
Let's go on to 110 then. I moved 110 up before the substantive instructions based on the first draft that went out. Madam Clerk, could we just make instruction 110 single space to make it consistent?
Yeah.
Okay, she'll fix the formatting a little bit, but substantively 110 just mirrors the charging language in the information. I am going to change victim A to Carlos Maldonado. I understand the victim designation in the charging documents, but at this point, Mr. Maldonado has been referred to by name. Any other changes to 110? All right. Instruction 70. I inserted here. I also have the additional line that's not standard in 70. It's about standby counsel being appointed. This is the same instruction that I gave at the beginning of the trial. Any changes to 70 as presented? Okay. What I propose here is to add something to 70 to address the defendant's clothing. I know when the defendant first appeared in Jail Orange, I gave the instruction to the jury that they are not to consider his change in appearance and his change in clothing. I'm proposing something that's similar to instruction 314, which is to be given when the defendant is wearing a visible restraining device in the presence of jurors. It would simply be that a sentence is added to 70 saying the defendant has appeared in court wearing orange clothing. This must not be considered by you in any way and must not influence your verdict in any manner. What does the state think of that proposal?
No objection, Your Honor.
Mr. Lychwick, what do you think of that proposal?
No objection.
Okay, then we'll add that the defendant has appeared in court wearing orange clothing, period. I think I'll add, you must not infer anything from this. And this must not influence your verdict in any manner.
Period.
This must not influence your verdict in any manner. And also change the spelling. I think you got infer now. I-N-F-E-R. All right, as presented, is that still okay with the state?
Yes.
Mr. Lychwick?
Yes.
Very well. Then instruction 110 is the standard first-degree intentional homicide instruction. It does use the victim's name. Madam Clerk, can you make this left justified, please? So just highlight the instruction and then, no, just the individual text. Nope. Below that, line below that, you see the center is highlighted?
Yeah.
To the left of the center. Nope, other one. There we go. And then put a paragraph.
You want me to do it to every?
Yep.
Sure.
And then could you, first paragraph, or first line indent on those paragraphs too?
Oh, yeah. I think I copied and pasted from the PDF. Didn't work very well.
Go back to that last paragraph, please. Okay, and then deciding about intent, we'll fix that. Intent and motive, we'll fix. Any other changes to 110 or requests for any additional instructions from the state?
No, Your Honor.
Mr. Lychwick?
None.
Very well. Then 194 is standard. If we can just put the first line indents, thank you. And then for elements, please separate out 1 and 2. So put 2 on the second line and give it one more space in between there.
Sure.
Thank you. Other than that, that instruction is standard. Any changes? Okay. 140 is a standard instruction. Madam Clerk, if you could just put extra spaces between the text and the heading. There you go, just like that. .145 is standard. 103 is standard. Can we break those paragraphs up, please? 162 we don't need. I don't believe there have been any stipulated facts.
I agree, Your Honor.
Okay. We'll take 162 out. 165 can be removed. There are no judicially noticed facts. 170 will remain in. Circumstantial evidence, we'll just take out the all caps language and also break those paragraphs up. Is the state requesting 172?
Yes, Your Honor.
Flight, escape, and concealment. Mr. Lychwick, any objection to 172?
Would you please go over that again?
Sure. 172, a flight, escape, and concealment is a supplemental instruction to the circumstantial evidence instruction of 170. What it says, or how it would read, is that evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state is requesting that. I'll hear an objection if you have one.
So the state wants this in?
Yes.
I object.
Okay. Noting your objection, I am going to give 172 primarily because one of the crimes is hiding a corpse, which itself is conduct after the alleged offense was committed. There's also other evidence that I believe would be relevant to having instruction 172 given. So we'll use the after the alleged crime was committed language. And unless the state wants the second bracketed language as well, Attorney Tombasco?
No.
Okay.
That's fine, Your Honor.
175, is there a request from the state for 175 motive?
Yes, Your Honor. I apologize for interrupting. Yes.
That's fine. Mr. Lychwick, do you want 175 or do you have an objection to 175? That is the instruction dealing with motive and that it is not. I'm sorry?
No objection.
Okay, then we'll include 175. I think it's appropriate given the charge of first-degree intentional homicide and the mention of motive not being required and different from intent in the instruction itself. So we'll take out that, those brackets, we'll leave that language in. And then we'll leave that second paragraph as is. All right. 180 deals with statements of the defendant. The state has introduced video statements, so the court will give 180, and we'll use the plural. We do not need the optional statements about the lack of audio or visual recording because the only statements the state introduced were the recorded statements, I believe. Is that correct, Attorney Tombasco?
Yes, that is correct, Your Honor.
Okay. So we'll take that out and then continue with the final paragraph of that instruction. Instruction 270, I don't believe we need. We can take that out. 157 will stay. I will modify 157 to say, remarks of the parties or parties. And then I'll say remarks of the parties are not evidence. Any objection to that change, Attorney Tombasco?
No, agreed, Your Honor. Thank you.
Mr. Lychwick?
None, thank you.
154 is summary. The state did introduce that timeline, which would be a summary. So based upon that alone, the court will allow 154 to be read. 155 is standard for exhibits. 148, we did have objections and evidence received. We'll change objections of counsel to objections of parties. Yes, thank you. And then in the second paragraph, by allowing testimony or other evidence to be received over the objection of parties, of the parties. 147 is standard for improper questions. The court did not allow some questions to be answered, so that will stay in. 150, I don't know that we had stricken testimony, but we had some stricken comments.
Mm-hmm.
Is there a request from the state for 150 to stay in?
Yes, I would. I don't know if we want to modify it to stricken statements rather than testimony, but
I'd leave it as is, but Mr. Lychwick, do you have any input on 150?
I have no objections.
Okay, I'll leave 150 as is. 190, weight of evidence is standard. 195, juror knowledge is standard. 300, credibility of witnesses is standard. Could we just break those paragraphs up a little bit for ease of readability? Mr. Lychwick, at this point, and I am not asking you for your final answer yet. I have not taken your waiver colloquy on your right to testify, but are you still anticipating that you will not testify?
Yes, I am, Your Honor.
Okay. Then for this credibility instruction, we will for now take out the paragraph to be given only when the defendant testifies. If, Mr. Lychwick, you change your mind about that, we can go back and modify this instruction. Then 315, Mr. Lychwick, if you do not testify, are you wanting 315 in there? It is an instruction to the jury that informs them of your constitutional right not to testify and that they must not consider your decision not to testify against you.
I want that in there, please.
Okay, then the court will give 315. We'll just break those two sentences up. 141, identification of the defendant.
Judge,
Attorney
I think,
Tombasco?
yes, thank you, Judge. I think I think it should be removed now. The only area where it might have been an issue was on the trail cameras, but I think as Mr. Lychwick has acknowledged yesterday, he said it was him, so I don't think that there is an issue regarding identification. I ask that it be removed.
Well, his statements that it was him are not evidence, and those would be regarding the statements of the parties that the court has instructed the jury not to consider. But still, I'm inclined to agree with the state. I think this instruction is more appropriate when there is an eyewitness to the crime who identifies the defendant as the one who committed the crime. Here, the only real question about identification was identifying the defendant on surveillance cameras and the trail cameras, which doesn't really get to the spirit of 141, I don't think. Mr. Lychwick, do you want instruction 141 to be given?
I want it removed.
Okay, then we'll remove 141. I don't think it's necessary in this case. Instruction 200, we have had testimony that could be considered expert testimony, so we'll leave 200 in. We'll just remove the word expert from that. And we can take out the optional paragraph at the end about conflicting expert testimony. We didn't have any of that. 201, opinion of a lay witness. Again, we'll take out non-expert in the title of that, but certain witnesses have been given the opportunity to offer an opinion based upon their experience, so my inclination is to leave 201 in. I don't know that we need to identify the specific witnesses who are allowed to give opinions. We could have it read, ordinarily a witness may testify only about facts. However, in this case, witnesses were allowed to give opinions based on their experience in determining the weight you give to this opinion. You should consider the witness's opportunity to observe, et cetera, et cetera. That way we're not highlighting any particular witness, but just acknowledging that certain witnesses have been able to give opinions. Attorney Tombasco, any thoughts on 201 as modified?
No, Your Honor, I agree with the court's thought process.
Mr. Lychwick, any opinion on 201 as modified?
Not at this time, Your Honor.
Okay, then we'll give it as written now. We did have hypotheticals, so the court will give 205, and we'll just remove the word expert. .320, I don't know that we had prior inconsistent statements, so we can remove 320. Attorney Tombasco?
I would intend to agree. The only thing I'm a little bit hesitant is if he testifies, it might become an issue, but at this point, I would agree.
Sure. If Mr. Lychwick testifies and that becomes an issue, we can add it. Otherwise, 320 will come out. 325 can be removed. We did not have any witness with prior conviction. 327 similarly can be removed. 340, credibility of child witness, can be removed. 160 is standard. We'll change that to parties. Thank you. And then 460 is standard. We can change counsel to parties in that instruction as well. Let me just put the parties in both of those changes just to make it read a little better. And then we'll use the plural of offenses. And then 480. So we'll have two verdicts on each count. The first verdict will be guilty of first-degree intentional homicide as charged in count 1. Second will be not guilty of first-degree intentional homicide as charged in count 1. Then put a space in between. There you go. Thank you. Can you also first line indent those?
You want me to do, no.
Yes, please. Thank you. Then similarly, we have guilty of hiding a corpse and not guilty of hiding a corpse as charged in count 2. Otherwise, that instruction is pretty standard, and then our verdict forms will mirror that language. Then 515 is a standard instruction.
Excuse me, Your Honor.
Yes, sir.
Could I have 480 reworded for reversing this to one reading, we the jury find the defendant, myself, not guilty, before guilty is placed in the text?
Any objection from the state?
That's fine, Your Honor.
Okay, the court will make that change. And then, Mr. Lychwick, what I will do is when the physical verdict forms are presented to the jury, I'll have not guilty on top and then guilty on the bottom.
Thank you very much, Your Honor. Thank you to prosecution.
So 515 is standard then, and then we have the closing instructions, which we will handle when the time comes. My practice for polling the jury is if the verdict is an acquittal on all counts, I'll do a collective polling of the jury, just ask the jurors to raise their hand if that is their verdict. If one or both of the counts result in a guilty verdict, I will individually poll the jurors and have each juror asked individually if that is their verdict. Are there any other changes that the parties are proposing to the jury instructions?
None from the state, Your Honor.
Mr. Lychwick?
None for me, Your Honor.
Then we will print up verdict forms too and have those distributed to the parties before we get to that point, so the parties can review those. So in terms of timing, Attorney Thompson, how much do you think you have left with Detective Stern?
Under an hour.
Okay. And then, Mr. Lychwick, you'll have an opportunity to cross-examine Detective Stern. At that point, is the state resting?
Yes.
Okay. We will conclude the testimony of Detective Stern. We will take a break outside the presence of the jury. I'll hear any motions from the defense. I'll talk to you, Mr. Lychwick, about your decision whether or not you want to testify. If you do not testify, you have no other evidence that you're presenting. Is that correct?
I would like to enter into evidence my defense exhibits 1 and 2, the Axon body footage chain of evidence log is for Officer DeBaca and Officer Tyndall for the car stop on the night of 1 December 2024.
So this is just a chain of custody log for that body camera?
Yes, and I believe it's probably already entered into evidence, but I want it entered specifically as my defense exhibit 1 and 2 as proof of to support my allegations of tampering of evidence.
Mr. Lychwick, the only body camera that's been introduced as evidence in this case is the body camera of Detective Stern. And it was only the 2 clips from the interview with you outside your apartment during the execution of the search warrant. There have been no other body cameras introduced into evidence in this case, and the jury has not seen any other body cameras in this case. So the chain of custody doesn't relate to Detective Stern's body camera, correct?
It does not.
Okay. So you are not intending to play the body cameras of those officers, are you?
I could, but I am not able at this time to demonstrate the tampering that was done to it. I don't have the wherewithal to do that at this time. I've been trying to do that over this past 18 months. 8 months when I discovered, through discovery, that the footage was tampered with both digitally, visually, and audially.
What witness are you going to introduce those exhibits in through?
I don't have an expert witness at this time. I wasn't able to come up with one. I'm still searching.
Is the state stipulating to the admission of those exhibits?
No.
Okay. Mr. Lychwick, without an exhibit or without a witness, I don't know how you're going to get those exhibits in. I understand that you've expressed a desire to have an expert witness for many months now. And this case has been pending for a long time. I've discussed with you your right to get an expert and your right to prepare a defense. But the trial was this week, and if you are without an expert witness for that, there's not much you're going to be able to do to get that evidence in and get the allegations in that I think you want to get in. What I will let you do, Mr. Lychwick, is this. When it comes time for, or when we're done with the state's case, when we take that break outside the presence of the jury, what I will allow you to do is provide an offer of proof to the court, and that would become part of the court record. So what it is essentially the testimony that you believe you would have been able to get in had you had an expert witness in this case. Okay? I'll allow you to make that record. I'll take your exhibits. as part of your offer of proof, but that would be just for the court record. It's not something that the jury would hear because you don't have the witness to testify about that. So for purposes of appeal, if you want to appeal this case, if you are convicted, your offer of proof would at least be part of the record then.
At this point, it sounds somewhat fair, Your Honor.
Okay. Well, we'll take that up again when we take the break at this close of the case. The close of the state's case.
All right, thank you, Your Honor.
Mr. Lychwick, then if you do not testify and if you do not have any evidence, would you like to formally rest in front of the jury where you say the defense rests, or would you like me to do that on your behalf?
I'll take care of it, Your Honor.
Okay. Then the only other thing I want to go over with the parties here before we bring the jury in are the exhibits. Again, I want to update what my record is of the exhibits and confer with the parties. Attorney Thompson, do you anticipate having more exhibits?
Yes.
Okay, that's fine. We'll do a final count later. Right now, what I have is in and published exhibits 1 through 50, and that includes 1A, 1B, 1C, 28A, 34A, 41A. I'm going to do these in batches of 50 because that's how I have my list organized. Is that correct from the state?
Yes.
And Mr. Lychwick?
I'm not exactly sure, I'm sorry, where we are with what we're discussing here.
Sure, we're discussing the exhibits. I just want to summarize the exhibits that have already been received and published to the jury. So my records show that 1 through 50 plus all of the sub-exhibits with diagrams and markings, 1 through 50 have all been received and published to the jury.
And I believe I objected to all those already anyway.
I think you have, and they have been introduced over your objections. So your objections noted.
Right.
My clerk informed me that we had a problem with 1B. That was the aerial photograph with the markings of Miss Nelson. The system indicated that 1B was captured with Ms. Nelson's markings, and my clerk got the notification that it was captured, but it, for whatever reason, did not save. So unfortunately, we do not have 1B saved in evidence.
Now, is 1B the aerial photograph of the top of the hill or at the point where the decedent's body was discovered?
Exhibit 1 was the Google map of the apartment complex and the surrounding area. 1B was the same Google map with Michelle Nelson's markings for, I think she placed 2 markings on there. One was a line, one was a small circle. We lost the capture of her markings on that exhibit.
So this is separate from the exhibit where I asked the witness to put what was really a dot over the spot where the decedent's body was discovered, proving that it was in that location. This is not having to do with that exhibit, right?
Judge, would it be helpful if I pulled up Exhibit 1?
Sure.
That would help, thank you.
So, Mr. Lychwick, this is Exhibit 1.
Right.
And then Exhibit 1B was this same exhibit, but with Ms. Nelson's markings for, let me review my notes here. I'll tell you. Yes, this was on cross-examination when you had Ms. Nelson mark where the body was, and I believe where she approached.
That is a very important exhibit to my case, Your Honor. I think we should maybe ask her to place her markings there again for the jury to see, to make sure that there is no doubt.
Well, I understand that that was the focus of your cross-examination with Ms. Nelson. It was done while the exhibit was up on the screen. So the jury did see that. The jury saw her making those markings, and it was up on the screen for a little time. So the jury has seen it. It would just be a matter of if the jury requests to view Exhibit 1B again, they would not have that available for their viewing.
Your Honor, I think it's very important that somehow that marking, at least where the decedent's body was discovered, be placed on there again for them in the green highlight marker.
Attorney Thompson?
I think it's pretty clear from all of the other scene exhibits where Mr. Maldonado's body was located. So I agree with the court. The jury, just like they have to rely on their collective memories about individual witnesses' testimony because they're not getting transcripts, this would be a similar scenario where they have to rely on their collective memory about the specific markings on 1B, but I think there are other exhibits in which we could get that information from.
Mr. Lychwick, I tend to agree with the state. I don't think there's much dispute in where this body was. We've seen multiple photographs of the actual location of the body. So the witness's drawing of where she remembers the body is less probative than all of the other exhibits that show exactly where the body was located. Furthermore, as I said, the jury already saw Ms. Nelson place those markings on Exhibit 1, and that was done while the exhibit was up on the screen. So they can rely on their memory of where she made the dot on the exhibit. So unfortunately, it's just not available. It's a glitch in the system. All of the other markings in this case have been captured. We just lost 1B for some reason, and I can't explain why that happened.
Your Honor, that's not satisfactory to me, the defense. I must insist that that marking be placed where she had placed it.
All right. Well, Mr. Lychwick, I note your objection and I note your frustration with it, but at this point, I don't think there's anything we can do to recreate that. So we will move on with the exhibits. For the next batch, 51 through 100, I have all of those received into evidence, and they have all been, that also includes 59A, 80A, 81A, and 87A. All of those exhibits have been published to the jury except for 58, which is the Wiedenhoft CV, 75, which was Ms. Gummon's CV, and 76, which was Ms. Gummon's report. Does the state agree?
Yes.
Mr. Lychwick, do you agree on that?
I don't really understand what I'm agreeing to again at this point.
I'm just recapping which exhibits have been received and which exhibits have been used with the jury.
Have I objected to those particular exhibits already?
Most likely you objected to some of them. A number of them were received while you were sitting mute and not participating. So I don't remember which ones were received over your objection, but your objection, if you made them...
They've been covered already, Your Honor.
Yeah, it would be covered already and it would be part of the court record.
Well, at this point, I don't think there's much I can say about that then.
For the next batch, 101 through 150, I have 101, and then I have 108 through 143, and 145 through 150. That includes 145A, 146A, and 150A. All of those exhibits have been used with the jury except for 108, 109, 110, 111, 113, 115, 117, 140, 142, 143, and 149. Does the state agree?
Yes.
Mr. Lychwick, do you have anything different on that?
I don't really know what these exhibits are. I probably have them in my files here somewhere, but it would take too long to go through them and look at them, and I don't have access to a computer, so I can't just bring them up. I don't know what I'd be agreeing to or disagreeing to.
Okay, well, if the time comes Well, the bottom line, Mr. Lychwick, is that it's your responsibility to keep track of the exhibits, too. The official court record of what exhibits will be received will be maintained by my clerk. I'm just trying to do a courtesy to the parties to verify that my clerk has the correct information. So that's all. The official record will still be maintained by the clerk. All right, the next batch, 151 through 200, I have all of those exhibits received into evidence except 153 and 154, which are the two boxes of Luger ammunition. There was no 181. Otherwise, everything else is in. And as far as publication to the jury, the ones that have not been published are 151, 151A, 153, 154, 155, 156, 177. That was one of a series of photographs of the L2 vertebrae with Dr. Scheel. The others were used. 177 I did not mark as actually having been used. 179 was not in and not used. I should have specified. I think I forgot about that one. 179 was not in and not used. Otherwise, is that consistent with the state's list?
Can you please repeat what you said regarding 153 and 154, which is the boxes of ammunition? I thought I heard you say they were not admitted.
I have them marked as not admitted, Madam Clerk.
Okay.
I don't have note of either one of those.
Okay.
I know they were referred to. I just don't believe the state has moved those in yet.
Okay.
Mr. Lychwick, is that consistent with your recollection or your memory?
Well, I would definitely object to their being admitted.
Sure, the state hasn't moved yet. I was just asking if the overall list was consistent with your notes or memory. Then the final batch after 201, I have 201 through 212, all admitted and published, and 215 through 219 admitted and published. Is that consistent with the state?
Yes.
Mr. Lychwick?
I wouldn't know what to say at this point with that, Your Honor.
Understand. Very well. Anything else we need to take up before we bring the jury back?
Yes. I have a question for the court. Exhibit 213, which is one I intend to use with Detective Stern, that is a recorded video call of the defendant in the Waukesha County Jail with another individual. Now, he has told the jury, and the jury can see at least that he is in orange, and in this video he will be in orange. It shows him coming out of his cell to start this conversation. So how I intended to try to mitigate is to ask Detective Stern, did you watch a recorded video call between Mr. Lychwick and another individual on June 10th of 2025 and not reference jail? I'm playing a portion of it where you do not see him coming out of the cell. It's towards the end of the conversation. I don't know if the court has any other way in which you want me to continue or additionally try to mitigate, but it's a video call, and that was the best that I could come up with to not draw attention to that fact and instead focus on the words of Mr. Lychwick.
Has that video been provided to the defense?
Yes.
Is it possible to play the video without, or play the file without the video and have it just audio?
That would be fine. When I publish to the jury and when I play it, we can just take it off of the screen so that maybe we can see it here at council table. But that...
The audio would still be going? That would be the easiest way to do that, and then it can be characterized as a call, or you can characterize it as a video call,
okay,
however you want to, just not reference jail, and then the audio will be played to the jury.
Okay, I can do that. Thank you.
Mr. Lychwick, does that proposal sound appropriate?
It does, but I would like to object. I haven't had a chance to object to the introduction of that piece of material into the prosecution's evidence against me, as that video call was a conversation between myself and, at the time, my power of attorney, Alan D. Fisher. He was my power of attorney. It was a private call, Your Honor. Detective Stern had no right to interfere with that, to snoop into that call.
Attorney Thompson, who is the call with?
It is with Mr. Fisher, but I'm not aware of any kind of power of attorney.
I have paperwork to that effect, Your Honor. I have the draft copy. I don't have access to a Xerox machine here, so I have copies of the draft copy of his contract being my power of attorney, and Mr. Fisher has returned that upon expiration of it. He has returned it, and it is sitting in my mail being held for me at the Waukesha Post Office at 600 Broadway.
What do you have in your possession, a draft contract?
The draft of the actual contract with Mr. Fisher being my power of attorney.
When did you enter into that contractual relationship with him?
I believe it was the later part of the mid portion of the year 2025, probably around March of 2025. And he remained my power of attorney, I think, until October of that year when it expired.
Was the nature of the discussion in this conversation legal matters or anything related
Yes, it was.
to power? Hang on. Or anything related to representation or anything within the purview of a power of attorney, Attorney Thompson?
Well, I'm not sure what the nature of this power of attorney is, whether it's medical or financial, but the nature of this conversation is that this individual confronts Mr. Lychwick with what the evidence says was recovered from his vehicle during the search, and then Mr. Lychwick responds, he doesn't know anything about that gun. He's never seen that gun before. It's inaccurate that it was a Luger that was used to murder Mr. Maldonado. And he also is asked about the items he removed from his storage unit to place in his trunk that where we eventually found the firearm. And Mr. Lychwick acknowledges that those are his war bags and that he lists items that we actually did recover in those bags. So it shows his knowledge of the bags, and what I would argue in closing is that conveniently that's the one item in the bags that he claims to have no knowledge about, but everything else in those bags he knows about. So it's relevant specifically to this case, but they're not talking about legal theory in this section. If the court would like to have an in-camera review, I can certainly do that. I have the timestamps, but this is specifically related to his acknowledgement of his war bags and the firearm recovered.
Mr. Lychwick, what was the nature of your relationship with this individual in terms of power of attorney? Was this for health care, financial, or what?
It was for everything, Your Honor. He was looking after my interests. He had my life in his hands. I had no one else outside helping me at the time. He was my de facto legal presence outside. He was trying to help me legally as well, find legal representation. He had right to know about this case. He was curious as to, he had looked up, with my permission, the criminal complaint and studied it over, and he was wondering what was in these bags that they were writing up, having taken out of the trunk of my car. And I unashamedly apprised my power of attorney what was in there. And it was, again, I stressed this was a private call between me and my power of attorney.
Well, Mr. Lychwick, what did the contract say? Was it a financial power of attorney? Was it a healthcare power of attorney?
It didn't specify. It specifies he is my power of attorney. This is a testimonial that you are my power of attorney. I don't believe I have it with me. It's in another file, but I can bring it for the court. I can access it for the court.
Is it in your materials in your cell?
It's in my materials in my cell. I just can't. It's one of my files in there.
Attorney Galaviz, do you have any knowledge of the power of attorney and what it would encompass?
No, sir. I've communicated with Mr. Fisher, and he represented that he was Mr. Lychwick's power power of attorney.
How long is the video?
The clip itself, I would be playing from 24 minutes and 37 seconds to 26 minutes and 6 seconds.
So it's a 2-minute or so video clip?
Yes.
And this is for the purpose of tying the defendant to the items that were recovered in his trunk in his car that he was driving at the time the items were recovered, after police watched him remove those items from the storage unit that lists to the defendant, and the defendant contracted to rent.
Yes.
All right, I'll have to take a look at it. I'm going to take a look at privilege as well. Let me do that now. Do you have it on a thumb drive?
I do, yes.
What exhibit would this be?
This would be 181. Oh, no, I'm sorry, 213.
While the court is reviewing that, Mr. Lychwick, would you be able to find the contract that you have in your materials?
If I could have access to my other files, I'm sure I could locate it, Your Honor.
They're in your cell?
You know what? I just might have it with me because this file contains my attorney.
All right, why don't you take a look at your
My attorney-related
materials?
business. It might, but then I might have filed it with. Let me check here, Your Honor, please. And the state, let me check. I might have it. I just might have it here. This is my attorney sub-file. But I may have.
Attorney Thompson, do you have the thumb drive? All right, we'll take a short break. I'm going to review this. What was the timestamp again, Attorney Thompson?
24 minutes and 37 seconds through 26 minutes and 6 seconds.
And is it labeled as Exhibit 213 on here?
Yes, it is.
Okay, Mr. Lychwick, while I'm reviewing this, you can go through your documents. We'll stand in recess.
The amount of force used was unreasonable. Mr. Mew is guilty of first-degree intentional homicide if he caused the death of Isaac Schumann with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of first-degree reckless caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you reasonable doubt.
Everything you've seen in this trial, the horrific injuries, the death of Isaac, why didn't he just walk away? His only explanation when testifying was, I stood my ground. I stood my ground. First of all, Wisconsin is not a stand your ground state.
Objection. Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nikolai. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nikolai did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends. He recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nikolai would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. Nikolai is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly it wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough. And it shows Nikolai seeking Dante out and stabbing him when his group is in the opposite direction. Nikolai walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
Can we have the screen, please? So here at 2 minutes and 6 seconds, this is after Nikolai has stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nikolai's not by himself. Two minutes, 8 seconds, that's the last you'll see of Nikolai until you see him walking off in this video. You see Dante, or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nikolai was doing at this point, even though this video didn't. here in a moment. You can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larion's video, Dante's just been stabbed. The next you see of Nikolai, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Take it down. Oh, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Bang running to Isaac. Let's see Larion's video. Okay, I have the screen. Remember, Nikolai admitted he walked up to he walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nikolai, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nikolai walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex Bang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nikolai and Larion. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nikolai, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense. And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA, how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nikolai's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nikolai punched Madison. She has zero connection with the group anymore, zero contact. Her and Quentin broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nikolai towards Nikolai's group. Nikolai turns and stabs him twice. Another one I submit to is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nikolai to leave. In the middle, when Nikolai turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking calling names to Nikolai. Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nikolai smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nikolai never said anything about being choked, never said anything about pain on his neck. Even when specifically asked by the SART nurse, never mentions anything. And the video doesn't lie. So on the left, Nikolai has just stabbed Riley, who you heard from multiple witnesses were just standing there. Tony comes to try to break it up. Nikolai stabs him twice. Isaac, just off frame, I submit to you, he just saw Nikolai stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nikolai. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nikolai's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Can we take the screen down?
Yes.
I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nikolai stab two people who posed no threat to Nikolai. Tony was breaking up the fight. He had actually ignored Nikolai at first, walked past him, pushed Dante out of the way. Riley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13 on 1, 13 on 1, implying it's some sort of mob beating up Nikolai. It's not even 13 people yelling at Nikolai. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nikolai's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. So it's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13 on 1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Can you turn on the screen, please? This is the second time you saw in the video that Nikolai turns his back on the boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. You don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife. The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Madison and Riley. He was getting pushed. They're lightly touching his arms and they're tiny. They're not in his face. We can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nikolai looking for the phone. So Eric Von Williams from Nikolai's group, you heard testify, before any of this happened, he was concerned about Nikolai's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nikolai not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nikolai went. Sandy said he went twice, was back for 5 to 10 minutes, then went again, over by the boys. Defense argued in opening that the boys' goal, their goal was to humiliate Nikolai. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nikolai. What about Nikolai? 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was boozing and drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nikolai has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nikolai's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nikolai had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nikolai is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, he was in the army, he doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nikolai is this feeble old man, they ignore that the only 2 people actually standing close to Nikolai are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nikolai run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nikolai to try to explain this transition. From 0 fear to 10 out of 10 fear, he's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nikolai, the demonic look on his face, staring through people, smirking. Defense argued in opening it's a slide tour here, there. You know after seeing the video so many times that's not the case. When he's not glaring, he's smirking in the video. Recall I asked Ernesto, his best friend, when he was trying to describe the shock of Nikolai, I asked, was he smiling? He didn't say, yeah, he smiles when he's scared, he smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nikolai was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? Defense had tried to argue there's rocks unstable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and responding to Nikolai punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nikolai just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nikolai did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife.
Quick matter, appearances are the same. The court had an opportunity to review the proposed.
So let's talk about the punch to Madison.
213.
I submit to you that evidence shows clearly, beyond a reasonable doubt, Nikolai punched her, she fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross. Well, she's not wet, she didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nikolai, she gets punched and falls backwards, and then their attention's back to Nikolai because Dante's hitting him. They're not going to see that she caught herself. They're going to think
I wanted to get a
she fell down.
sense of how the conversation with Mr. Lychwick.
Look at her position next to Riley. They're shoulder to shoulder in front of Nikolai before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Riley,
particularly
and Maddie is back. She clearly got knocked backwards.
Mr. Lychwick makes reference
Her sunglasses aren't on her head anymore.
trying to pay this other individual and pay his expenses.
Defense has a double standard about that too. If there's not a photo of it, it didn't happen.
Already looked into.
If there's not a photo of an injury, it didn't happen.
The individual was at the defendant's apartment.
We know Nikolai got punched.
Had
He
access
didn't have
to
any
Mr.
injury.
Lychwick's mail and bills and knew Mr. Lychwick's utility balance and other things like that. I briefly reviewed the contract.
Defense can't have it both ways.
Titled
So, turn and talk a little bit about memory, credibility.
What the court finds
Obviously,
important
the
here
witness's
is
memory is better
differences
closer to
between
the
an
event. That's
attorney-client
obvious.
relationship and
Alcohol's going to affect memory, traumatic events going to affect memory, how fast it happens is going to affect memory.
Chapter 905 of the Wisconsin
But
statutes.
crucially, and
And
absolutely
under
crucially,
905.1,
there's a huge difference
lawyer-client
between getting some
privilege
details wrong,
to
right hand, left hand,
relationship
sequence of
between the
events,
who in
and
this
making
case
up
is
an
a person
entire
and a
story
lawyer who is a
like
person
Nikolai did.
authorized or reasonably believed by the client to be authorized to practice law. in
Defense has tried to highlight throughout the trial,
That is
Nikolai
different
was in this traumatic
from
experience,
Chapter
give him a break.
244, which covers
It's understandable, he made up this huge, all these lies,
244,
told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff.
a power of
Talking
attorney
to
is a
Lieutenant
writing
Hart.
or other record that grants authority to an
But
agent.
don't
to
give
act
any
in
sort of
place the
credence to
principal,
the theory
whether or
that
not
trauma
the
affects
power of
memory
attorney is
for
used.
anyone in the Carlson
Essentially,
group,
what this
any of the boys, any who were
document
stabbed,
is, and
any who
what
had to
Mr. Lychwick
drag
says
Isaac
his
is
relationship with
bleeding
this
to
individual
death to the
is a
shore.
power of attorney.
AJ
which
was
grants this other
disemboweled.
individual
Don't give any credence
the power to
that trauma
act
might
in
affect
place
their
of Mr.
memory
Lychwick.
and how accurately they can remember all
That
the
is
details.
different than
But Nikolai, who
acting
invented
as
an
a
entire
lawyer
story,
that would establish a
tried to
lawyer-client
skip through the
privilege.
crowd.
In that case, a lawyer is
Give
someone
him
who's
credence
authorized
for
to
that.
practice law. There's no indication that this other person
You
is
saw
authorized to practice
what
law.
happened to all these
And
witnesses, how
throughout the
fast it
conversation
happened.
with this individual, Mr.
It's not
Lychwick
surprising,
makes
some of the
reference
details
to
are wrong. But the major
consulting with
point
his lawyer.
is accurate,
So this
is
was during the time when
consistent.
Mr. Lychwick had representation.
This all started when Nikolai
from the defense
punched
lawyer
Madison,
to handle
whether it's the
the
right
case.
hand or left hand.
Mr. Lychwick had conversations with the other individual about,
You heard the
His
turmoil
and
of the boys
a portion that
when
the
they
state
realized
proposes
Isaac
to
was
be
stabbed.
played from 24
Clearly a traumatic
to 2606 is not in furtherance of legal representation.
There's a
It's
big
not
difference
asking
between
the
details
other
and
individual
invention.
to
Think about
make certain
the
representations
most basic
to
example.
Mr. Lychwick's
You
attorney.
and say your
It's not
partner go to the
asking
grocery
this
store.
other individual
Park
to
your car,
stand
you're
in
leaving the
Mr.
grocery
Lychwick's
store, you
place
think your car's parked over there,
and
they think
have
it's
a
parked
further
over here.
conversation
You
with
still know the car's
attorney
parked in the
on
parking
triggering
lot, even if you can't
attorney-client
remember where it's parked.
So I don't
Same is true
believe
for the
that
punch
this
to Madison.
conversation implicates a lawyer-client privilege. Power of attorney is much different than what would be,
You heard from 10 people from,
Client relationship.
both from the Carlson
and
group,
therefore,
And
for
the
that
boys group.
reason, I will, over the defendant's objection,
That
allow
Nikolai
the state to
struck
play
Madison.
213 from 24 minutes, 37 seconds to 26 minutes and 6 seconds. As I said before, we'll play it audio only so that the video does not demonstrate that Mr. Lychwick is in custody.
So what about,
The video
let's talk a little
will play.
bit about witnesses from Nikolai's group. Ariel, what did he say?
All right, the
At trial, he
documents that Mr.
says
Lychwick
Nick defended
submitted will
himself.
be made
Can't really
part of
say
the
how.
record of Mr. Lychwick's.
Never said that when interviewed with law enforcement. He denied even being close
Anything else then
to
from the
Nikolai.
state?
Remember,
before we-
Ariel was there when he
I
stabbed
would just
Dante.
note that
He was right there when Nikolai stabbed Riley,
when you,
Tony,
assuming that
and
I have
Isaac.
Mr. Fisher's name
Law
spelled
enforcement
correctly,
went there with the frame of Ariel standing next to Nikolai when Nikolai has the bloody knife.
He is
Ariel
not a
denies seeing
licensed
anything
attorney,
to
at
law
least not
enforcement.
in the state of Wisconsin.
Okay, thank you.
Of what Nikolai did.
Mr. Lychwick, anything else before we bring the jury in? I can't think of anything, Your Honor.
Ernesto,
Then let's call for the jury.
at trial, testified he didn't see Nikolai get hit, just saw him down in the water. Said he couldn't remember Nikolai saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, "Nikolai, get out," Nikolai walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, "I wasn't asked that question." But he described that event. He also wasn't asked more than 10 times if Nikolai said they took my knife.
Yeah, well, this way.
So, about the punch to Madison again. Sergio, he's in Nikolai's group. He had walked out a little ways. You can see him in the photo on the left, in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nikolai and say, "Go, go, go." He said it repeatedly to law enforcement. And he said Nikolai pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nikolai do anything to Madison unless she got pushed back, punched back, something violent, not some light push. He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nikolai just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Mandy testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, don't worry about it. This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat.
Good morning, ladies and gentlemen. I apologize.
In determining whether Nikolai's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, and whether such retreat was feasible, and whether he knew of the opportunity.
We've taken care of.
He turned his back on them multiple times facing open water.
Would have required.
People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable.
Other things and can get going now. So with that, Detective, you are still on the witness stand.
You heard from
come back up and
Sheena Bull, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Weyer, and Alex Bang. Alex Bang originally described him as you heard from Owen that he heard
Attorney Thompson, you may
impact
proceed.
and saw
Thank you.
Madison.
Detective
fall back
Stern,
into
there are a couple areas that I'd like to.
Defense has to
circle back on
argue
with
that they're
you
all either
before I
lying or mistaken.
Finish
All
where
these witnesses,
we
including
left off
Sergio.
yesterday. In front of you on the witness.
If they're lying, why would
exhibits
Quentin say I saw some
154.
swelling and
And can
some slight
you
redness, but
remind
didn't see the
us
punch?
what
Why wouldn't he
those
just say, yeah, I saw the
exhibits
punch too?
These are
Why
boxes
wouldn't
of 9
Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could.
Was that as a result of the search warrant that was executed on?
The punch isn't on video, but you
December
see
2nd of
the reaction.
2024?
You hear Dante
I
yell,
will
you
move
can't hit a
exhibit
woman
153 and
before
154
Riley is
to
stabbed.
Mr. Lychwick, any objection to the admission?
They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all these people
Now, Detective Stern,
standing
we
around
also talked
Nikolai
yesterday about
in that
the grid
half
search
circle,
that was
approximate
performed the
shape.
day after
They're all
Moxie
looking
went through the
in that
property at
direction,
1512
including
Amesmore.
Sergio,
Do you
including
recall that
Sheena, who's
topic
by
of
the
your
group,
testimony?
the tubes for the Carlson group.
And
They all were wrong in what they saw.
you were referencing divots that you observed at the top of the hill in the area of one of Moxie's
Another
final
defense
responses. Do you recall that
double
as well?
standard.
Yes.
It's relatively minor,
Do
but I
you
submit to
remember
you it shows that
approximately
they're
what
grasping at
time on
straws.
November 20th you and
Is
your other
this
officers went
trying to
back
put Nikolai's group in a
this
different
property
category.
to actually conduct
There's
this grid
drunks on the Apple
grid
River,
search?
then there's Nikolai's group. About half of you
I don't
raised your
recall
hand
the
that you've been on the
exact
Apple
time.
River.
That's the
That's what people do on the Apple River.
Around
They go out, they
10,
tube,
11
and they drink. Nikolai's in the
light
exact
out or
same
dark
boat
out?
they were in.
It was light out.
He wasn't bird watching and this
Now,
group of drunk teenagers ran up on
We
him.
was
He knew what it's about.
Specialist
He'd been on the river
Schmidt
before.
taking photographs during this grid search.
Yes.
Madam Clerk, can you turn on the screen, please?
Another thing about
For the
the
witness only.
punch to Madison. You heard that they didn't get to see the video before giving their statements. Even Jawan, who took the video, said he got far enough to get the screenshot.
Detective Stern, I'm
Nikolai,
showing you what is marked
and
as
then law
State's
enforcement took
Exhibit
his phone.
220.
He didn't get to see the video.
Do
You
you know
saw
what
what
Exhibit
happens in this
220
case if somebody
Yes, this is one of the
lies
photographs taken
about
during
something
the
that happened on
grid
video.
search.
Because Nikolai
And
got burned.
what
He made up
specifically does
complete and
Exhibit
total lies.
220
Video showed he wasn't telling the truth.
document?
The video
about
happens
this
to
grid
not show the
search?
punch,
These are the
but it
two
still
exhibits I
corroborates
described
what all those witnesses said.
And, well, actually, first, I would move Exhibit 220 into evidence and ask to publish to the jury.
Any objection to the receipt of Exhibit 220?
Yes. I object.
That objection is noted. Exhibit 220 will be received. Any objection to
So,
publication of 220?
Count 6 is battery to Madison Coleman.
All right, and again, Exhibit 220.
It has
will
4
be
elements.
Allowed to be published.
Nikolai caused the battery to Maddie, or caused the injury, the
Now,
harm, the
first,
pain.
on
She
your
testified
screen,
to that.
Detective Stern, I'm showing
He
you what has
intended to cause the
previously
harm
been
despite his denial.
admitted and published to
Just
the
make sure
jury
that's
as
clear.
Exhibit 87.
Don't punch somebody without intending to cause harm.
Can you
She
remind
didn't
us what is in
consent. She
Exhibit
testified to that.
87?
This is what we've been referring to as the top of the hill, the far back portion of the property at 1512 East North Street. And that further back where you see the more of the green coming up, that was the area that we discussed the final train response from K9 Moxie.
And if we look at Exhibit 220, can you circle for me where you see these divots that you're talking about? Can we please screen capture this and mark it as 220A, and I would ask that it be received?
Yes, it will be received as 220A with the markings. Please wait a moment while we confirm the capture.
I haven't.
Now, Madam Clerk, can you please clear the screen for me? If we go back to Exhibit 87 here, Detective Stern, I'm going to ask you to mark 2 different areas of Exhibit 87, if you can remember. Can you please circle where Moxie had her final trained response in this area? And then can you also circle or put an X where these divots are that we just saw in Exhibit 220? Can we please screen capture this and mark it as Exhibit 87B? And I would ask that it be received.
It will be received as 87B, just to clarify the record. Then the first markings that the detective put include the green arrow, which is simply a product of touching the screen, and then the green line right above the arrow. The second marking for the divot was placed where the X is.
Thank you.
I haven't.
Thank you. Now, Detective Stern, on November 20th, when you and your fellow officers were conducting this grid search, what was, sorry, I'm trying to think of how exactly I'd like to ask this. Strike that. When you and your fellow officers are conducting this grid search, is it easy or difficult or something else to hear each other?
It was difficult to hear up there. That was one of the biggest notices I noted, one of the things that we noted the most. This was the most amount of time we spent up there based on the methodical grid search that we were doing that day. We noted that you can't really see the road from there, and with the traffic noise during the daytime and some wind that was coming through, we were having difficulty hearing each other while we were speaking to each other. And we were speaking about that as we were conducting this grid search.
Now, how far away are you guys from each other when you're conducting this grid search?
I mean, as we're doing the grid search, if one person's working on one square and one person's working on the other, we're about 3 to 5 feet away from each other.
And approximately how wide were these squares?
Approximately 3 feet by 5 feet.
So, am I understanding correctly that it was difficult to hear each other even though you're only 5 feet away from each other?
That was what we noted.
Now, we left off yesterday talking about Mr. Lychwick's arrest on December 6th of 2024. Do you recall leaving off at that topic?
Yes.
Now, on December 6th of 2024, after he's arrested, is he brought back to the police department?
Yes, he was.
And are you in an interview room with Mr. Lychwick at the department?
Yes, I was.
Were you present when Detective Barrett came in to execute the buccal swab warrant for Mr. Lychwick's buccal swabs?
Yes, I was.
Prior to having any discussions about the facts of this case that we are here to talk about today, did Mr. Lychwick make any comments to you about activities related to German gun shows or arts or pieces of art or artifacts?
Yes, while we were in this interview room, we were making kind of small talk, and he talked about art business that he was involved in, and then he mentioned again that he had traveled a lot back and forth from Germany to America in his youth, how much time he spent there, and then he talked about how he would take artifacts from Germany while he was over there and bring them back, and that he could find people that would purchase them, specifically at antique shows and gun shows.
Madam Clerk, can you turn on the screen just for the witness, please? Detective Stern, when I say an interview room at the City of Waukesha Police Department, are those rooms equipped with audio and visual recording devices?
Yes, they are.
Okay. If you look on the screen in front of you, what is marked as States Exhibit 181, do you recognize the room that you're in?
Yes, this is one of our interview rooms at the Waukesha Police Department.
And do you recognize the individuals in this video?
Yes, I am wearing a green jacket. Mr. Lychwick is wearing a gray long sleeve shirt.
Okay. And this particular clip, which is 58 seconds long, does that detail the conversation or record the conversation topic that you just testified about?
I believe it will.
I would ask that Exhibit 181 be received, and I would ask to publish to the jury.
Any objection to the receipt of Exhibit 181, Mr. Lychwick?
I object.
Okay, over the objection, it is received. Any objection to the publication?
I object.
Over the objection, it may be played with the jury.
All right, I'm playing from the 0-second mark.
I was already selling antiquities and art since I was like 15, going back and forth from Europe. I started with the military antiques. My dad's buddies at work wanted this, and everything had to have a swastika. I still can't get over that.
Really?
Everything had to have a swastika with these people. I mean, the American collectors, everything, they want this Nazi garbage left over. And there was plenty of it left over in Europe.
Right. Yeah.
I was getting it for nothing over there, and I was bringing it back here, and I was making tons of money. And I was laughing at these people, you know, moth-eaten uniforms and flags, and these guys were almost fighting each other at the gun. I was selling them at gun shows.
Yeah.
And you had all these different types of people there at the gun shows.
There's some crazy, some crazy people at the gun shows.
I'm telling you, I remember a lot of the gun shows I went to in Milwaukee, and the Milwaukee County tactical squad guys would be walking through checking for illegal stuff.
Now, strike that. Now, the one thing I was going to ask you about the buccal swab is, during your research into Mr. Lychwick, were you able to determine if he had an identical twin?
He does not have an identical twin.
Did you talk earlier about how he had a younger brother?
Yes, he does have a younger brother.
Okay. Now, did there come a time where you reviewed a recording that involved Mr. Lychwick and another individual on June 10th of 2025?
Yes.
And during that recording, was there a part where Mr. Lychwick referenced war bags?
Yes.
Okay. Can you give the jury a general overview of that particular part of that recording?
Yes, during that recording, the individual asked him some questions about information that had been made public post the preliminary hearing, and he then basically discusses what was found in his vehicle. And he describes them as my war bags. He also accurately describes some of the things that were in the bags that we had located from the search, indicating to me that he knew about these bags and that these were his. They were not anybody else's.
I object.
What's your objection, sir?
The prosecution here has their witness inferring that the term war bags is sinister. But as an Air Force veteran, the detective knows that the bags we carried our equipment in were called war bags.
Mr. Lychwick, your objection is noted. The jury can draw appropriate inferences from the evidence. It's their determination to make. So the objection is overruled. And as far as it relates to the admission of the defendant or the detective's testimony, go ahead, Attorney Thompson.
Madam Clerk, can you please turn on the screen just for the witness? Detective Stern, up on the screen in front of you momentarily will be State's Exhibit 213. Do you see that exhibit?
Yes.
And is this the recording that you listened to from June 10th of 2025 involving Mr. Lychwick?
Yes.
Had you reviewed this portion of the recording prior to your testimony today?
Yes.
And is it a fair and accurate depiction of the recording when you listened to it for the first time and notated that in your report?
Yes.
I would move Exhibit 213 into evidence and ask to publish the audio to the jury.
Any objection to the admission of 213, Mr.
I
Lychwick?
object.
Okay, your objection, as previously discussed, is noted for the record. The court will allow Exhibit 213 to be entered into evidence. Any objection to the publication of the audio only, Mr. Lychwick?
Yes.
All right, your objection's noted, and the court will allow audio publication of Exhibit 213.
Okay. I am starting at 24 minutes and 37 seconds. Pausing at 26 minutes and 6 seconds. Detective Stern, is that the conversation that you heard when you first listened to this recording?
Yes.
Now, if we move on then to an additional warrant that you completed during the course of your investigation, specifically related to Mr. Lychwick's Gmail account. Do you recall that?
Yes.
And since the screen is still only up in front of the witness, I am going to show you what has previously been marked as State's Exhibit 214. This is a 12-page document, and as I scroll through, please follow along with me. Okay, do you recognize Exhibit 214?
Yes.
And generally, what does Exhibit 214 contain?
214 contains examples of search terms and visited websites that I received from Google in response to the search warrant that I submitted to them for this case.
And how did you determine what Mr. Lychwick's Gmail account was?
The Conrad Lychwick at gmail.com, as previously discussed, was discovered being used in his phone. After that was forensically downloaded and examined.
And when you reviewed those records, do you recall the time frame in which you received the records from Google?
Yes, I requested and was approved by the judge for January 1st of 2024 until, I believe it was December 6th, the time of his arrest.
Okay. Did you go through those Google returns?
Thoroughly.
And do you know about how many pages there were?
The Google returns are a very large document. There is a lot of data that Google holds for those accounts. If I had to estimate pages, it would be thousands, if not tens of thousands, if you were to print them out individually. It is quite a lot of data.
In your experience, or actually, first I will ask, in your capacity as a detective, have you ever prepared warrants for Google records before?
Yes, I have in previous cases.
And have you reviewed Google records before in your past investigations?
Yes, I have.
Based on that experience, are you aware of whether Google or providers of that nature keep things in their records that may not necessarily be maintained on an individual's phone?
Yes, based on my training experience, data that's held on the phone, if you write to the company that owns that account, they will likely have or can have more information than what's actually still contained on the physical phone.
Is Exhibit 214 a document you prepared in anticipation of your testimony in this case?
Yes, it is.
And does it contain any searches or items that you determined were of significance in the investigation into Mr. Lychwick?
Yes, it does.
And are these, how did you prepare this document?
I prepared this document by physically going into the Google returns, specifically the search history portion that was provided to me by them. And then I basically created screenshots of the searches that we found that were likely related to this investigation.
Now, did these records come from Google in UTC form?
Yes, they do. It's standard that these companies will put the timestamps in UTC. Therefore, it's on us to convert them to the proper time zone.
And in this case, when we are converting to the correct central time, depending on the time of year, whether it's daylight savings time or not, would we be subtracting either 5 hours or 6 hours from the UTC time in the Google records?
Correct. Based on whether daylight saving time is in effect or not, based on those dates, it would either be minus 5 hours from UTC as central time or minus 6 hours from UTC as central time.
Okay. I would move Exhibit 214 into evidence and ask to publish to the jury.
Any objection to Exhibit 214, Mr. Lychwick?
I object.
Okay, the court notes also document 94 filed by the state prior to the trial, so based on that as well, the court will allow 214 into evidence. Any objection to publication, Mr. Lychwick?
I object.
The court will allow publication of 214 to the jury.
I am not going to go to the full screen. Instead, I will zoom in because some of this is a little small. Now, Detective Stern, when we start on page 1 of Exhibit 214, what are the first couple pages of this exhibit referencing?
These are various visited sites or search terms regarding storage spaces from November 1st, 2024.
When, or what was the date Mr. Maldonado's remains were recovered?
October 30th, 2024.
Now, when we see in particular, the first two searches on the screen right now, we can see viewed and we can see visited. Do you know what the difference is between the two of those?
I do not.
Okay. Now, if we continue scrolling then, the next search that comes up, so now we have a total of 3 searches on page 1 of this exhibit. Is this another storage search?
KO storage, I believe, is another storage search.
Now, what is the date on these searches again?
November 1st, 2024.
And so if we were to convert the UTC time to Central Time, would these times be approximately 8:28 a.m., 8:22 a.m., and 8:46 a.m.?
Yes.
Now, did you see more searches related to storage units on November 1st of 2024 then?
Yes.
If we continue to the bottom of page 1 of Exhibit 214, and we continue onto page 2, are there still more searches for various storage units?
Yes.
Okay, now continuing on to page 3, are we still seeing units, or I'm sorry, searches for storage units on November 1st of 2024?
Yes.
Now, all of these searches between the first 3 pages of Exhibit 214, if the first one would have been at approximately 8:22 a.m. on November 1st, if we convert it to Central Time, from your review of the records, how long throughout the day was Mr. Lychwick searching for storage units?
I recall the math that I did between the first and the last one on that day was approximately 9 hours of time.
When you were reviewing these Google records going back to January of 2024 until November 1st of 2024, did you ever see any searches related to storage units on Mr. Lychwick's Gmail returns?
No, from January 1st of 2024 until November 1st, there were no other searches regarding storage units.
Now, in Exhibit 213, we heard something about a 38 referenced by Mr. Lychwick. Do you recall that?
Yes.
Did you see 2 searches in those Google returns from February 1st of 2024 related to that?
Yes.
Okay, can you describe for me what these searches are?
Yep, one is a visited site for 38 special firearms for sale at Bud's Gun Shop. And then another was a searched for 38 caliber revolvers, 38 cal revolvers available today.
In the search of Mr. Lychwick's vehicle, did you ever recover a 38 caliber revolver or firearm?
During the search of that vehicle, no 38 caliber.
Objection.
What's your objection, Mr. Lychwick?
Item of truth. He's lying.
Mr. Lychwick, that is not a proper objection. I'm instructing the jury to disregard the statement by the defendant. The answer will stand. Detective Stern, you may continue your answer.
Not only during the search of the vehicle, we did not recover or locate any 38 caliber as described in that audio clip that we heard. We searched his apartment twice, and no 38 special as described was ever, of any kind, was ever located in his apartment or his vehicle.
As you continued going through the Google returns, on February 1st of 2024, did you note searches related to jumpsuits or overalls for sale?
Yes.
When we consider what is included in Exhibit 214 later on, did these particular searches become relevant to you in connecting to some of the later searches?
In terms of the searches from the Google return?
Yes.
Yes, they become relevant.
Okay. Now, if we continue then, were there searches on these Google records for carcass disposal?
There were viewed websites. I did not locate any search term that led him to there, but he was at, or this account was using or viewing websites regarding carcass disposal and disposal of spoiled food.
This search that we have in front of us on page 4 of Exhibit 214, what is searched for?
On April 21st, 2024, there is a search for map of landfills in Wisconsin.
Is there a search that happens approximately a half hour after the map of landfills search?
I don't know if it's a search or if it's a viewed site. That's right here is the visited. So it was not a search, but a visited a website where the article was entitled Carcass Movement, Processing, and Disposal. It was from the Wisconsin DNR website.
Okay, and thank you for correcting me on that term. So when you receive these Google returns and you see visited, are you able to click on the link to take you to the article?
Yes.
And did you, in your review and preparation of Exhibit 214, go to that article and include screenshots of it in Exhibit 214?
Yes, the following screenshots are from that link that we see as the visited.
And April 21st of 2024, how many days is that after Mr. Maldonado was murdered?
Approximately 7 days.
And when we consider the date of this search in reference to the trail cam footage from May 2nd of 2024, how many days in between that are there?
Approximately 10 days prior to the videos from May the 2nd.
Now, if we continue scrolling on page 5 now of Exhibit 214, is this the article that we saw was visited regarding carcass movement?
Yes.
And can you describe for the jury then what information is contained in this article?
Yeah, this article is talking about CWD, or I believe it's chronic wasting disease, with deer, moose, elk. And then it notes some sites where there are sample and disposal locations. If someone was to suspect that the animal they may have harvested might have CWD.
I object.
What's your objection?
These inferences are unfounded, unproven connections with this case.
Okay, as far as it relates to relevance, the court will overrule the objection on relevance grounds. And as for inferences, Mr. Lychwick, it is up to the jury to determine the proper inference to be drawn from the evidence introduced. So the court will allow the testimony to stand. Attorney Thompson?
As we continue through Exhibit 214, does the article continue that you have screenshots here?
Yes.
Okay. Now, what are we seeing on page 6 of Exhibit 214?
So this is the Wisconsin DNR's suggestion for how to dispose of a carcass. They're speaking about deer and harvested animals. However, I noted that their opinion was that carcass waste should be disposed of so that it ends up in a landfill. There was some other notable: dispose of your deer carcass waste in a landfill, transfer station, municipality curbside pickup. Bury the deer carcass. That was another suggestion by the DNR on how to handle it.
When we come to the recommendations for hunters section, are there 3 suggestions by the DNR on how to dispose of the deer waste or the carcass.
Yes.
And are they listed in order of effectiveness? Per
Yes.
the DNR.
Per the DNR, the article indicates the following options are listed in order of effectiveness.
Okay, what are the 3 options?
Dispose of your deer carcass waste in a landfill, bury the deer carcass waste, or return it to the location of the harvest.
As we continue then onto page 7, what did you note about the suggestion in this article about moving a carcass?
The safest option for disposal is to ensure the waste ends up in a landfill.
In your review of these records, was there any suggestion about using opaque or black bags?
You don't see it on this article that there's another article that recovers this, but under the processing your deer, there's the standard direct common sense for hunters or anybody that's handling a carcass to wear rubber gloves and minimize contact and all that.
Objection.
Your objection?
The defendant was asked whether the color of the bags was important in this article, and he hasn't substantiated that.
Okay.
His explanation.
So the objection is essentially non-responsive. The witness did answer the question and clarified that there was another article that dealt with that, so I'll allow the witness's answer to stand. Again, the jury can infer inferences.
As we continue through and finish the DNR article, at the bottom of page 7 of Exhibit 214, is there a notation for another website that is visited?
Yes, it was another article. This one is from the USDA. How can I dispose of spoiled food safely?
And what is the date of that search?
This is also at April 21st, 2024.
Were you able to then place or follow that link and have a screenshot of what the user would have seen if they had followed that link?
Yes, that link is depicted in the screenshot below the visited annotation.
And what, if anything, did you observe that was relevant to the investigation into Mr. Lychwick?
The USDA's suggestion in this article that was viewed by this account, it's very short and simple. When disposing of spoiled food or products possibly contaminated with botulism, place the food, swollen metal cans or suspect glass jars in a heavy opaque or black garbage bag. Close and place the bag in a regular trash container or bury it in a nearby landfill.
As we continue going through the Google records, did you also observe searches for paper bags?
Yes, I did.
Okay, and are those denoted here at the top of page 8, both on April 21st of 2024 and April 22nd of 24?
Yes.
Now, we have heard some information from the Operation Starling note, which I believe was Exhibit 147, about Minnesota. Do you recall that part of the note?
Yes.
And as you go through these Google returns, did you see searches or visits or viewings related to Minnesota?
Yes.
Okay. Now, February 12th of 2024, what is this search?
Latest Minnesota missing persons.
Then, as we continue, is there a search from, actually, sorry, strike that. On page 8 of Exhibit 214, in the 2 searches closest to the bottom of the screen, what are these searches?
There are 2 searched terms here. Can stress cause the tongue to swell up? Both of them are the similar search, yes.
Okay. Now, right now this date is April 16th of 2024 at 4:40 and 25 seconds a.m. in UTC. Is that correct?
That's correct.
So if we go back 5 hours, would Central Time actually be April 15th of 2024 at 11:40 and 25 seconds p.m.?
Yes.
What is the significance of that then related to Mr. Maldonado?
It's approximately 24 hours after he would have been killed.
The next.
Objection.
What's your objection, Mr. Lychwick?
The state and the prosecution do not know exactly when when the poor decedent was murdered.
Okay, Mr. Lychwick, that is an inference that the jury can draw, and they can assign the proper weight to the evidence as they see fit. The witness's testimony will be allowed to stand. Attorney Thompson, you may continue.
This next search after the stress question, what is that search for and what date was that?
On May 20th, 2024, there was a search for ACLU, which I believe is the American Civil Liberties Union, for police surveillance.
And approximately how much time is in between this search and the day that Mr. Maldonado was killed?
Approximately 4 to 5 weeks.
As we continue to page...
Objection.
Your objection?
What exactly does that have to do with this case? Relevance.
Okay, the relevance objection is overruled. Attorney Thompson?
Moving to page 9 of Exhibit 214, what was visited by Mr. Lychwick?
He visited basically the link is still twitter.com, but it was specifically Brett Lemoyne, who is a local reporter, and a Twitter post.
And if we, what's the date?
It's October 31st, 2024, 1:29 a.m. in UTC.
So if we subtract 5 hours from that time, what would be the central time, date, and time of this visited action?
I am no good at math, but it's late night on October the 30th.
And did you follow this link to find this particular, or to see what the post was?
Yes, I did.
And is this a screenshot of what you saw when you followed the link?
Yes.
Now, what is the next viewed item that you could see?
The City of Waukesha Police Department.
And if we subtract from UTC time, that would be approximately 9:25 p.m. on October 30th. Is that fair?
Yes.
Now,
Objection, Your Honor.
What's your objection?
At this point, I think everybody in Waukesha was looking up that site to see what was going on there, including my other neighbors.
Mr. Lychwick, that's not an objection that would prevent the testimony from coming into the record. You can argue that inference, but it's not an objection to prevent the testimony. The testimony stands. Attorney Thompson, you may continue.
the section that is on top of page 10 of Exhibit 214, the first box, if you could read that for us, please.
Sure. November 25th of 2024, 3:43 a.m. in UTC. Search for Waukesha News for November shooting.
And first, if we convert that to Central Time, would that then be November 24th at 10:43 p.m.?
Yes.
Okay. Now, in the context of this investigation and that timeline in Exhibit 164 we were looking at, what happened shortly after on November 26th of 2024?
On November 26th, we executed the first search warrant at Mr. Lychwick's apartment.
Okay. Oh, I'm sorry. Go ahead. Now, this is specifically a search that we can see. Is that correct?
Correct.
Okay. Now, on November 24th, Mr. Lychwick searches for Waukesha News for November shooting. at this point in your investigation, had the fact that Mr. Maldonado been shot been released to the public?
As of November 24th, no, it had not.
Objection.
What's your objection?
This has nothing to do with the homicide investigation ongoing at 1512 North Street.
Mr. Lychwick, your objection on relevance is overruled. The testimony will stand. Attorney Thompson, you can continue.
The next box that we see here on page 10 of Exhibit 214, what was visited?
It was a news article entitled "Officers Find Body Wrapped in Tarp Near Frame Park in Waukesha."
And again, in converting this, would that have been November 24th of 2024 at approximately 10:53 p.m.?
Yes.
Did you then follow this link to the article that was visited?
Yes.
Okay. In looking at this particular article, can you see when the original posted date was?
Yes, October 31st, 2024.
Okay. And now Mr. Lychwick is searching for this on November 24th of 2024. Is that correct?
Correct.
Now, as we continue through Exhibit 214, did you then see at the bottom of page 11 any search terms from January 9th and 12th of 2024 that had relevance to you?
Yes, the weather in Sturgeon Lake, Minnesota.
Objection.
Your objection, Mr. Lychwick?
What does that have to do with this case? That's my private life.
Mr. Lychwick, that objection on relevance grounds is overruled. The jury can draw its own inferences from the testimony. Testimony stands. Attorney Thompson?
As we continue through the last page of Exhibit 214, are there additional searches related to an individual listed on the Operation Starling note?
Yes, searches for Raven Tanya Frederick with other various qualifiers behind him.
When we reviewed, and let me know if you'd like to see Exhibit 147, but when we looked at Exhibit 147, do you recall seeing anything related to obstacles or potential obstacles to that operation?
Yes.
Was there anything related to getting in and out of different states?
Yes, there's. If you gave it to me, I'd be able to read it verbatim. Otherwise, I could summarize.
May I have permission to approach?
You may.
Okay. Detective Stern, I've given you State's Exhibit 147, and I'll give you an opportunity to review that.
I have it.
Okay. Is there anything in there about getting in and out of certain states undetected?
Yes. Right here, obstacles to operation. It is secrecy and entering and movement in and around Minnesota without leaving a footprint.
The last search on page 12 of Exhibit
Objection.
2.
Yeah. Are you objecting to that answer or this question?
The answer and the question.
Okay, I'll take your objection to the answer. I haven't heard the question yet, but what's your objection to the answer?
The objection is that, quite simply,
Mr. Lychwick, again, without testifying, give me your legal basis for the objection.
I simply did not search for anything like that.
Mr. Lychwick, without testifying, give me your legal basis.
Lack of connection to the case, lack of proof that this is connected to the case, that I actually looked up something like that?
Okay.
Did they see me look that up?
That's a relevance objection. Your objection, like all of your other relevance objections, are overruled at this time. The jury can draw its own inferences from the testimony and determine the weight, if any, to give to this testimony. The answer will stand. I will hear the next question in its entirety. If you have an objection to the question, you may voice it at that time. Attorney Thompson?
What is the last searched for item on page 12 of Exhibit 214?
March 3rd, 2024, 6:51 a.m. UTC. Are there license plate readers at the Minnesota-Wisconsin border?
What is a license plate reader?
That would be a camera that would capture a license plate.
Thank you, Madam Clerk. You can take down the screen now. I do not have any other questions for this witness.
All right. Mr. Lychwick, cross-examination.
Detective Stern, you have maintained that you became suspicious of me because you stated that the victim's name was not on your search warrant, your first search warrant that you furnished me with on the 26th of November, 2024, and that I blurted out the victim's name while reading the search warrant. Is that correct?
I first became suspicious of you when you were identified in the May 2nd videos. However, I understand, I know what topic you're speaking of, yes.
But yet I have here a copy of the search warrant that was given to me in discovery, and the original copy of the search warrant is still in my apartment. And it states in there clearly.
Well, hang on. I don't want you to testify. If you have a copy of the search warrant, you can show it to the witness. My bailiff can have it delivered to the witness. The state will be able to see it first. Attorney Thompson, are you going to have any further exhibits after 220A?
No.
Then this will be marked as 221.
Okay.
I refer the witness to look at page 2.
Well, he has to have the document first. Mr. Lychwick, we're going to mark this as Exhibit 221.
Okay,
I'll have the bailiff show it to Attorney Thompson.
this is the final page of it. This is the final page of it. On page 2, Detective Stern, I believe paragraph 2, what does it read?
Carlos Maldonado's name is on this document.
That's correct, isn't it? Isn't it, Detective? Yet you maintain in your official reports even, and led this jury in court to believe that the guilty man would only know the victim's name, and that you're inferring that I was guilty of this crime because I blurted out his name, and you're saying it wasn't on there. You were lying, Detective, weren't you?
No, I was not lying.
But you stated a fact that was not in evidence here. That was not real. That was not in reality.
I did not testify to this during this trial.
But you did maintain in your official reports that are being used in this trial that that's why you became suspicious of me.
No. Again, the suspicion arose from the May 2nd videos. There is an error in my report where I believed that the name was not in there based on the draft that I had written.
Oh, now you're admitting that there was an error, but you don't bother to clarify that before now.
I'm going to object first. He didn't even let the witness finish. And second, it's argumentative.
Okay, it is argumentative. I'm going to allow the witness to finish answering the question that you posed, Detective Stern.
When I wrote my report, I did note his use of the name. I believe that based on the draft that I had written, which did not include the name, that was accurate. His name is on this warrant that was presented to him.
Okay, Mr. Lychwick, your next question.
Detective Stern, are you familiar with the search of the boiler room at my apartment building there?
Yes.
And you're aware then that the cadaver dog alerted to the boiler room, the interior of the boiler room?
Yes.
And are you aware that I had no access to the boiler room?
I'm not aware one way or the other if you had access to the boiler room or not.
You didn't bother to check that out, Detective?
I'm aware that you did not have a key issued to you for
That's
the boiler
right.
room.
There was no way I could have gotten into the boiler. I've never been in the boiler room. Was my scent discovered in the boiler room?
Okay, hang on. The jury will disregard the testimony of the defendant about whether or not he was in the boiler room. You have to ask questions. I think you were about to ask a question about whether or not your scent was detected in the boiler room.
That's correct, Your Honor.
Okay. Ask that question.
Was my scent detected by the cadaver dog in the boiler room?
My understanding of the cadaver, I'm not a canine handler, specifically you'd have to refer back to Ms. Gumman's testimony. The dog does not look for specific people's scents.
In your opinion as a detective in this investigating this matter, the lead detective, did you ever suspect that I had any access to the boiler room?
There were times when we were on the property where the boiler room was left wide open. So in theory, anyone who could get into the garage could get into the boiler room. But I am aware that he was not issued the key when it was supposed to be locked for the boiler room.
Are you aware that the boiler room was almost always locked?
I'm not aware because
I will ask Mr.
Hang on. You've asked a question. Let him answer.
I'm not aware because I do not have 24/7 surveillance on the state of the boiler room if the door is left open or not. We noted when we were there several times throughout this investigation, sometimes it would be open with no one around.
Well, I can prove then my point if I could summon the building's owner, Mr. Soper, to testify.
Mr. Lychwick, you have to ask a question of this witness. Ask a question. Do not testify.
Did you ever talk to Jeff Soper about the access to the boiler room and how often it's locked or left open?
I personally did not talk to him about that.
Did he ever mention anything to you about this?
No, because I did not talk to him about that.
Are you aware of your interviews and initial suspicion of the building's groundkeeper named Nathan Pauley?
Yes.
And are you aware that Mr. Pauley did have access to the boiler room?
Yes.
Are you also aware that Mr. Pauley spent a lot of time habituating the area, the actual area in which the decedent's body was discovered?
No, I'm not aware of that.
I was told that you knew everything about this case.
I'm going to object. That's not a question.
That is argumentative. That is stricken. The jury is to disregard that. Mr. Lychwick, ask a question.
Did you ever interview any of my neighbors or other witnesses at my building who saw Mr. Pauley habituating the area where the decedent's body was recovered?
I'm going to object because that is going to call for hearsay.
No, the question was, did you interview any other neighbors or witnesses? So I'll overrule the objection. The witness can answer.
Yes, I interviewed neighbors and witnesses, not regarding Mr. Pauley. I would reflect back to Detective Bloom's testimony about Mr. Pauley being eliminated as a suspect in this case.
He may have been eliminated as a suspect in this case, but that is not the specific questions at hand right now.
That's also not a question, Mr. Lychwick. Ask a question.
Detective, was Mr. Polly, Nathan Polly, of apartment 1 at 1512 East North Street, an initial suspect in this homicide?
Yes, he was investigated as a potential suspect.
And was he cooperative with you and your department?
Yes, he was.
Your Honor, this contradicts.
Mr. Lychwick, ask another question.
Was Mr. Polly ever uncooperative during your investigation of this matter?
No, as Detective Blumarty testified, he provided consent for the search of his apartment, the download of his cell phone, a DNA sample, all sorts of things that helped us continue this investigation early on.
Detective, regarding the missing .38 caliber pistol from my war bags, do you have a gun collection?
I'm going to object as to relevance.
Mr. Lychwick, what's the relevance of this witness's personal gun collection?
This has relevance in 2 points, Your Honor. To try to possibly connect the the detective to the presence of this firearm supposedly found in my war bags, and the missing .38 caliber pistol from the war bags.
Okay. The court fails to see the relevance in whether or not this witness keeps a personal gun collection. So on that basis, the objection is sustained. Next question.
Detective, in my attempts to retrieve my brand new cell phone that you confiscated from me and my other phone, especially before I had to purchase another phone, even though I had visited the station several times trying to get my phone back, you had initially promised me that you would return it right away and that the search of my phone would only take but a day. Is that not correct?
That sounds familiar, yes.
But yet you refused to return my phone. So you were being untruthful, weren't you?
No, I was not. To provide context for why not is because if there was nothing on the phone, then yes, it could have been returned as soon as it was searched. However, evidential value items were found after the phone, and the best practice is to not only use the download that was created, that image by Detective Fine, but to keep the original phone if there was ever a question of whether that download did in fact come from that phone. So I could not return that phone after it was determined that it had evidential value.
You still weren't telling me the truth, were you, Detective?
I don't believe that's an accurate characterization.
That the truth would have been to level with me and tell me what you were doing and to apologize for not returning the phone as you had promised. But you did not do that, did you? You were deliberately misleading me, weren't you?
I was not deliberately misleading. Once again, I don't know what's on the phone at the time that it's seized. If there was nothing of evidentiary value, then yes, the phone would have been returned. However, evidential value was located, so we kept the phone. There was no intention to deceive Mr. Lychwick.
But after it was supposed to be returned and you weren't returning it is what I'm referring to. You still didn't level with me. You were deliberately being misleading in this matter.
I'm going to object. That's asked and answered.
Objection sustained. This has been asked. It has been answered. Next question.
Your Honor, I'm trying to establish the credibility, the integrity of this witness.
The objection is sustained. Next question.
Detective, are you and any other police officers that you know involved in the fraudulent creation of case materials against citizens such as myself that you know are innocent?
I'm going to object as to relevance, and quite frankly, it's argumentative too.
Sustained on those grounds. It's argumentative. It's not relevant. Next question, Mr. Lychwick.
Detective, are you at all fearful of being exposed for corrupt conduct in this case?
I'm going to object.
Same objection, same ruling. Mr. Lychwick, ask an appropriate question.
I'm trying to, Your Honor. I really am.
Next question.
Detective, as far as one's movement around one's own property, or even on the street at any hour of the day or night, are we at Marshall, at the time of your investigation, before I was arrested and moving around on Mr. Lefebvre's camera in the backyard there, were we at martial law in this country, or was there a curfew established prohibiting citizens to be indoors instead of outdoors at those hours?
No.
Thank you. Do you have any proof that I walked on the so-called footpath towards the poor victim's body?
No, there's no definitive video showing that. We showed you the extent of the videos that we characterized to you as detectives believing that it was suspicious, that I believe it was suspicious.
Just answer the question, Detective, please. You've answered it. You said that you have no proof. Detective, on the mud that you and the prosecution are making such an issue about, that I was scraping off of my boots at the end of my hike through the back of my yard. Do you have any proof of where that mud came from, that it had any link to this case, or that the poor victim's location where he was resting there at the crime scene?
No.
Thank you. The L-shaped holster on my list that you refer to as a holster, do you now, I believe in your reports you admit you now, but the jury has not heard of this yet, I believe. You now admit that you know what that was. That was an old camera case, right? And you understand that the item in it was the green camping flashlight that you found in my car.
I'm going to object. That was never testified to. That's facts not in evidence. And the form of the question.
Your Honor.
Ask that as a question. Are you asking the witness, does he know if the L-shaped holster was a camera case and a flashlight? Is that your question?
Yes, it is.
Okay. The witness may answer that.
No, I do not know what's on his hip in those videos.
Did you not later discover what it was?
No, I still don't know exactly, to say definitively, what's on his hip in that video.
But if it pleased the court, you did seize those items from me. You have the case, it's in evidence, and you have the green flashlight, which was just shown to the jury yesterday.
Yes, there was a green bendy flashlight. It would require me to render my opinion. I don't believe the silhouette of in the video displays the very short flashlight. You'd have to compare it for yourselves to make that determination. Ultimately, I don't know what's on his hip in those videos.
Detective, in any way, shape, or form, as a man who's handled firearms and who has at least seen this evidentiary firearm that you're saying, that you're maintaining was used in the homicide you're trying to link to me, can you sit there and tell the jury that you think that odd-shaped, awkward-looking pistol was on my hip in those frames?
Again, I'm not saying what is or is not on his hip. I'm saying I can't. I'm not saying that it's a gun. I'm not saying it's a flashlight. I'm just noting the piece of equipment that he was wearing in that video.
Okay, Detective, but to try to explain this matter to you further and for the sake of the jury and the court, in your reports on this matter, which I can dig out if I have to, you maintain, you're trying to, in the report, it's clear that you are trying to make that look sinister by saying you felt it was a gun on the suspect's hip. Is that correct, Lieutenant? Is that correct, Detective?
Yes, I believe that the phrasing I use is that it is potentially consistent with.
Detective, in your work and your report writing as a police officer, do you use the terms operations and staging area and so forth a lot?
No, not in my work as a police officer.
But those are terms used in your work.
No, they're not.
You don't use the word operations?
Perhaps the TAC team or police, I'm not on the TAC team. They may use an operation or a staging area. Just in my general work as a detective, no, I don't use those phrases.
But you are familiar with those phrases because you have contact with the tactical team. Is that correct?
That's correct.
Thank you. Detective, when you and Detective Smith, or Specialist Smith, I'm sorry, I can't remember his title at this time, when you were in the pole barn methodically searching my car, my 2022 Kia Forte, do you not admit that you don't know what the duct tape that was in there, like anybody may have, was used for? That it only resembles what you're trying to link to this case.
Can you rephrase that, please?
Sure. Do you admit that you do not know what the duct tape that you located in my car, which was, first of all, Lieutenant, a sub-question.
Hang on. Okay. We got to ask really simple questions here. Okay. So ask a one-part question. Are you asking the witness, does he know for sure what the duct tape was used for? Or if you have another question in mind, just ask a nice, simple question that this witness can easily give it an answer to.
Detective, do you know what the duct tape was used for?
No, I don't know what anybody uses any of their personal items for because I'm not watching them 24/7. So no, I don't know what the duct tape may or may not have been used for.
All right, thank you. And in your opinion, when you found this particular roll of duct tape in my car in December of 2024 during your initially unwarranted car stop, the search was warranted. In your opinion, was the roll of tape brand new or was it used?
I'm going to object to that question. That is a legal conclusion for the court, which has already been decided, and the court has previously told Mr. Lychwick that.
The objection is sustained. The court is striking the question. Mr. Lychwick, you can ask a question without the editorializing.
I wasn't aware I was editorializing, Your Honor.
The issue of the stop of the vehicle and the search of the vehicle has been ruled on by the court. Ask a question.
Your Honor, I was stating what was already...
Ask a question.
So, Detective, you bring up the fact that I had to purchase a new phone, which, for all what you know, I would have done anyway, because the phone that you initially seized from me was an older phone, was it not? It was an older model of the Samsung series of cell phones, right? Lieutenant, right, Detective?
I know that it was a Samsung A12. I'm not familiar with where that falls in their mod. I don't know if it's older or not.
And then the second phone that you seized from me was my Samsung A15. Is that correct?
I believe that's accurate, yes.
And are you aware that the Samsung A15 is much better in performance than the Samsung A12?
I'm going to object as to relevance.
Overruled. Do you know?
I do not know, but I would make the assumption it is based on the newer model number.
You have never heard about, you never heard people talking up this particular phone or used one yourself?
No, I'm not particularly, I don't follow tech. That's not one of my things. I have my phone. I personally use Apple, so I'm not familiar with Samsung.
As far as my having to rent a new car when you were in possession of my car, I mean, from your reports already in evidence, you have seen that I was researching legal advice on this case already, and I was looking into filing a complaint against you and your department with the Fire and Police Commission, which is rather difficult to find in Waukesha. I had to do considerable searches to find
Judge,
it.
I'm going to object. I'm sorry to interrupt, but this is not a question, and it's the editorializing that the court
I'm
has.
trying to build up for my question, Your Honor.
I know where the question was going, and based upon what's in your question already, I'm sustaining the objection. That is not relevant. It has nothing to do with the facts that the jury needs to consider in this case. So confine yourself to questions that have relevance to what's at issue here.
I'm trying to, Your Honor. Detective, do you know exactly why I had to rent the rental car from Enterprise Rent-A-Car?
No, I don't know why, especially as I've previously testified. I offered and even drove to his house once to give him a ride back, that car could be released and would have been released to him. So I do not know why he rented a new car.
Do you know why I did not want to get into your car with you at that point and ride back to your station with you after your reluctance to return my things to me and after what you did to my apartment?
No, I don't know why.
Yet you make an issue of it. Why did you make an issue of it?
Because in the totality of the circumstances, what we've been looking at, what I knew at the time that we did that, at that point I knew about the matching of the ballistics and the DNA. Basically, based on the totality, I'm noting it as a suspicious behavior. I found it to be a suspicious behavior. We were going to give him his car back. We made several attempts, and he didn't.
You found that suspicious.
I did, yes.
That's a personal opinion. That's not any proven fact.
That's correct.
Thank you. Detective, are you also aware that I believe it was your second suspect was the decedent's girlfriend in this case?
Yes, there was another suspect in this case as well.
And may I ask the defendant to answer a question about the decedent's girlfriend?
The witness, you mean?
May I ask the witness of this?
I don't know what the question is going to be.
The question would be, did the decedent's girlfriend did she have a father, a brother who may have gotten involved in this case? Did they suspect any of her relatives?
You can answer that question.
Yes, both the decedent's girlfriend was investigated as a potential suspect, as well as her son-in-law was investigated as a potential suspect, both of whom were ruled out after the same residential search warrants, searches of cell phones, cell data, all of that went into each one of these three people that he's referencing, and nobody else provided any evidence that they were involved in this incident. Only one person had evidence that they were involved with this homicide.
Detective, is it possible that you missed something along the way?
Anything is possible, but I do not have any evidence to suggest that there was something missed.
Would you, may I ask the defendant, may I ask the detective to reiterate that anything is possible?
The answer stands. The jury heard it.
All right, thank you. Detective, did you suspect a motive initially of how and why this poor deceased girlfriend may have been involved in his homicide?
I'm going to object to that, and the basis is relevance, and I believe it is coming very close to the court's pretrial rulings on this issue.
The court sustains the objection. Mr. Lychwick, you've established that there were other suspects. The witness has answered that those suspects were ruled out. Motive is not anything that needs to be proven in a case, and the jury will be instructed about that anyway. So at this point, we're getting away from relevant evidence, and the court has already ruled pretrial. So you may continue with your questions.
Detective, on the matter again, if I could bring you back to Nathan Pauly, your first suspect in this homicide, this dreadful homicide, if you will. Is it true that your department was charged with trying to find Mr. Pauly to testify here during these proceedings?
During which time frame?
Just before we convened on the 8th of June, in the week at least before the trial began.
I was on vacation personally in the 2 weeks before this trial. I am not aware of what was going on at our apartment. I wouldn't be able to speak to what anybody was doing.
Are you aware that, are you at all aware of the fact that Mr. Pauly is missing?
No, I don't believe that he's missing.
You're not aware of that, Detective?
No.
Interesting.
Move to strike.
That's
Sorry?
stricken. Mr. Lychwick, we don't need the editorial comments.
Again, Your Honor, I wasn't aware I was editorializing. I'm sorry.
When you make comments after the witness's answer, that is editorializing. Ask your next question.
I will try to keep that in mind. Detective, have you ever heard the well-known saying that cops collect guns? They're some of the biggest gun collectors around.
I'm going to object as to relevance.
What's the relevance?
The relevance is to the suspicious appearance of these firearms in this case and the missing firearm in this case.
Again, whether or not this witness collects guns or knows that police officers collect guns is irrelevant here. Ask your next question.
Detective, when your thugs entered my apartment and destroyed...
That's enough, Mr. Lychwick. Either ask appropriate legal questions or I'm going to stop your cross-examination.
When your men entered my apartment and, Your Honor, and they destroyed my apartment.
I'm going to
Mr. Lychwick, ask a question.
When your men entered my apartment and destroyed my apartment, I have 5 pictures hanging on the living room wall, as you well know.
Judge, I'm going to object. This is going to continue being the defendant testifying.
Mr. Lychwick, what's the relevance of the pictures hanging on your wall?
The relevance, I'm trying to establish the defendant's character and his integrity here.
You are the defendant, Mr. Lychwick.
I'm sorry, Your Honor. I am trying to establish the detective's integrity and his ethics here, his morality.
If you have excuse me, if you have an appropriate legal question to ask, you may ask that. But I don't see the relevance of pictures on your wall. The editorializing that the officers destroyed your apartment is improper. So ask a question. If you have a specific question about the search of your apartment.
I do, Your Honor.
Okay, then ask that question.
Detective, I would like to know why members of your team chose to remove my picture of President John Fitzgerald Kennedy from the wall by my office area and throw it on the floor and smash it.
I'm unaware of any damaged property. I don't know anything about that.
You don't?
I do not.
Do you know of any hostile feelings towards President Kennedy or what he stood for amongst your officers?
I'm going to object as to relevance.
Sustained. Next question.
Your Honor, at this time, I believe that's all I have for the witness.
Okay, any redirect, Attorney Thompson?
I do have one question. When we look at Exhibit 87, which is the top of the hill where Moxie's train final response was, are there any lights up there?
No.
What about the footpath area where Mr. Maldonado's body was found?
I believe there's a light adjacent to the parking lot that would provide it there. That light might cast over there, but I don't know if I could say for certain if the light would cast over where the body was found or not.
I don't have any further questions. Thank you.
Mr. Lychwick, would you like Exhibit 221 moved into evidence? That is the search warrant that you showed to the detective.
Yes, please, Your Honor.
Any objection from the state?
No.
All right, Exhibit 221 will be received into evidence. Detective, you may step down. Attorney Thompson?
I do not have any further witnesses. The state would rest subject to any rebuttal.
All right, ladies and gentlemen, the state's initial case is concluded. That necessitates that we take a break. I anticipate that this might be about a 10-minute break, and then we might break early for lunch and come back after lunch. So for now, we'll take a short break, and I will call you back when we are ready. Again, because the state is rested does not mean that it's time to discuss the case.
All right, security.
Thank you. You may be seated. We are outside the presence of the jury. Mr. Lychwick, you indicated earlier that you wanted to make a motion at the close of the state's case.
Yes, Your Honor, I motion to dismiss.
All right. Do you want to present any further argument on that motion?
I have evidence with me today that I would like entered as Defense Exhibit 1 and 2 concerning the Axon body camera chain of custody, which would indicate...
Mr. Lychwick, let me just stop you, and I'll still hear from you. Sure. The motion to dismiss asks me to find that the state's case is insufficient as presented at this point. It doesn't have anything to do with any evidence that you would present or whether or not you testify. It's simply asking the court to decide, based only on the evidence and on the inference drawn most favorably to the state, that a jury could not come to the conclusion of guilt here. All right, so do you have any argument on that motion with that in mind?
Yes, I do, Your Honor.
Go ahead.
The evidence against me here, as I have long established for months now, is tainted. This case should have been thrown out 8 months ago at least, Your Honor.
All right. All of that has already been decided by the court and is irrelevant to the motion to dismiss. Nonetheless, the court considers the motion to dismiss, and as stated, the court draws all inferences in the light most favorable to the non-moving party, which is the state here. The court finds that the state has provided evidence here that there was a homicide at 1512 East North Avenue, that the victim was Carlos Maldonado, that the time of death was around April 14th of 2024, that the body was eventually dragged into a wooded area behind the apartment complex and was hidden from view. The state has also provided enough evidence to link the defendant to that homicide through items that were testified to, recovered from his car, his apartment, and certainly other evidence. There was medical information provided to establish the cause and manner of death, and the murder weapon being linked to the defendant. So based upon the evidence presented by the state, the court does find that the state has provided enough evidence for this case to continue to the jury, and the defendant's motion to dismiss at this time is denied. Mr. Lychwick, now is the time to talk about your decision whether or not you want to testify. Have you made a preliminary decision about whether or not you want to testify?
I do not wish to testify, Your Honor.
Okay. Mr. Lychwick, do you understand that you have a constitutional right to testify?
I completely understand that, Your Honor.
And do you understand that you have a constitutional right not to testify?
I understand that, Your Honor.
Do you understand that the decision whether to testify is for you to make?
I understand that, Your Honor.
Has anyone made any threats or promises to you to influence your decision whether or not to testify?
No.
Did you want an opportunity to further discuss this with standby counsel?
I have already discussed this at great length with standby counsel, but thank you for asking.
Have you come to a decision?
I have come to a decision. I do not wish to testify in this trial.
All right. The court will make a finding that Mr. Lychwick is aware of his constitutional rights. He is competent to make the decision whether or not to testify. The court will find that Mr. Lychwick has been following this case. He has asked appropriate and some inappropriate, but he has asked some appropriate questions of the witnesses. He has followed along. He has a certain case theory in mind, and he is smart enough to come to the decision on his own. And therefore, the court will find that the defendant is voluntarily giving up his right to testify and exercising his constitutional right not to testify. So the defendant will not testify, and the jury will be instructed as such, as we discussed earlier. Mr. Lychwick, aside from what I said before about allowing you to make an offer of proof, do you have witnesses that you intend to call?
Not at this time, but I do have the defense exhibits.
Okay. And again, as I stated, I will allow you to introduce those as your offer of proof, but those would not be coming in absent a defense witness. So I'm going to bring the jury back in. I will ask if you have any evidence to present. You indicated that you wanted to rest personally in front of the jury, correct?
That's correct, Your Honor.
All right. You can rest in front of the jury. I will then excuse the jury for lunch. We will come back at it's 11:30. We'll come back probably around 12:45 with the jury, or maybe we'll just say 1 o'clock with the jury. And then I'll excuse the jury. I'll let you make your offer of proof, and then we will break for lunch and we'll come back. Does that sound appropriate, Mr. Lychwick?
It does, Your Honor.
And Attorney Thompson?
Yes.
All right, let's call for the jury then.
What did he say about proof? What proof? When you come back before the jury comes out for closing. It's called what proof? Offer of proof. Offer of proof. Thank you. Okay. Remember, defense reps.
All right, jury.
Thank you. You may be seated.
Mr. Lychwick, at this time, does the defense wish to present any evidence?
The defense rests, Your Honor.
Okay. Ladies and gentlemen, at this point, the evidence in the case is concluded. You still have to be instructed and you still have to hear closing arguments before you may start your deliberations. Given the timing right now, the fact that it's 11:30, this is a good time to break for lunch. So we are going to break for lunch. We're going to break until 1 p.m. That gives you enough time to get lunch, take a break, for the parties to prepare for closing arguments as well. When you come back from lunch, you will be given the final instructions and hear closing arguments from the parties. So we will see you back at 1. Please do not discuss this case until you come back.
All right, Gary.
You may be seated.
We are outside the presence of the jury. Mr. Lychwick, I'll allow you to make your offer of proof. Had you had an expert witness, what do you believe the evidence would have shown?
The evidence would clearly show, Your Honor, that the Waukesha Police Department, headed by this particular investigation and action, was headed by Detective Benjamin Stern and perhaps 7 other of his detectives and specialists and officers, that they deliberately doctored the body camera footage from the car stop of December 1, 2024, at the beginning of the car stop when it initially occurred, and that the audio portion of Officer C.D. Baca in the driveway of my residence when he dropped me off has been deliberately altered.
Okay, Mr. Lychwick, let me just pause you. I'll continue to hear from you, all right? For an offer of proof to have any value on appeal, it has to be evidence-based. So what I'm asking you is, what are the facts, not the conclusions, not the argument, not your inferences, but what are the facts that you think an expert witness would have been able to show for you, and what are the exhibits that you want to introduce? So I don't want to hear you say the evidence was fabricated. My expert will say that the evidence was fabricated. That has no value for you on appeal. So tell me the facts that would have been introduced.
My expert witness will be able to pull apart the digital video, the Axon body camera footage, with a video editor, which is commonly available on any computer, and show what I have brought before the court. They will be able to show timestamps. Perhaps we're hoping to find Detective Fian's digital signature in there. Perhaps his calling card that he leaves when he does his forensic digital searches or modifications. I believe he calls it formatting. When that was done, he almost certainly will have left his calling card, or whoever was operating in the Waukesha Police Department who was doctoring these portions of the Axon body camera footage will have left these in there. It is well known, Your Honor, it is a technical fact that when you, at least at the point that we are now in this technology, that when you alter digital video or audio, there is a sign that you were in there. There is a sign that the person who did it was in there. And we're hoping to expose that, and we're hoping to expose the mere fact that this tampering was done, that these items were changed in these videos. The Axon body camera footage of Officer C.D. Baca and Officer Joshua Tyndall.
Now, Mr. Lychwick, the only times during this trial that I have heard the names of those two witnesses or those two officers has been from you when you voiced your objections. So none of the evidence in this case against you is reliant upon those officers. We have not seen their body cameras. We have not seen body cameras of any witness except for Detective Stern. So the other question that I have for your offer of proof is, what is the relevance of any of that evidence?
The relevance is, Your Honor, that these evidences are directly connected with this case. The car stop was executed, and these items were initially entered as evidence against me and furnished to me in discovery as evidence. And the fact is that they were deliberately altered to try to cover up something within the goings-on of the Waukesha Police Department. I am establishing, may I tell the court what I'm trying to establish here?
Sure.
I am establishing the fact that that my accusers have resorted to the tampering of evidence, and I have come across hard proof that they have, and I have some of it here, if I may go on, Your Honor, in their chain of custody for this evidence, showing considerable alteration with what they call in the if I may use the terms used for this technology, in the alteration of the checksum data in several places, especially with C.D. Baca's portion of the Axon body camera footage for that date and time frame, and for some suspicious and inordinate activity of the same type within the context of the Axon body camera footage of Officer Joshua Tyndall, who was also responsible for stopping me at that point in which my vehicle was seized, and it is being used. All the evidence is taken from the trunk, and everything are being used as evidence that have been brought up just recently during this portion of the trial as evidence against me. These officers were privy to this, and they were part of this action that is being used against me here, Your Honor.
Mr. Lychwick, do you have exhibits that you want to enter as supporting
Yes, I
your
do,
offer
Your
of
Honor.
proof?
And if I could get back the original search warrant that I provided the court from the
We'll make a
27th.
copy of that. It's Exhibit
For my records.
221.
For my records, Your Honor.
What I'll do, Mr. Lychwick, is I'll take those exhibits that you would have entered and mark them. Are there two of them?
Yes, there are, Your Honor.
Okay, I'll mark them as, we'll say 250 and 251.
Let me just make a note of that, Your Honor. Would this be considered a defense exhibit then, or just an exhibit?
The way we do the numbering doesn't differentiate between state witness and defense, or excuse me, state evidence and defense evidence. It's just sequential ordering, but I'm skipping ahead to 250 just to set these two apart. The last number in sequence was 221, which was your exhibit. But again, it's not labeled as a defense exhibit. It's just Exhibit 221. Anything else you wanted to say regarding your offer of proof, Mr. Lychwick?
Not at this time, Your Honor.
Okay. Anything for the state regarding matters to discuss before we come back at 1 for closings and instructions?
No, thank you.
Mr. Lychwick, anything else?
Not at this time, Your Honor.
Okay. I'll give you time to gather those exhibits, Mr. Lychwick, and submit them with the court. One other thing I'll note, too, consistent with how we've conducted this trial from the start, because of Mr. Lychwick's tethering to the floor, I'm going to have closing arguments delivered from counsel table.
May I stand at counsel table?
You may stand.
Okay, thank you.
And Mr. Lychwick, you may stand as well if you want to at counsel table when you are giving your closing argument.
Thank you.
Okay, we are adjourned until 1.
to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. He knew that. Punching Madison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, the knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nikolai's person. So what is the interference at the time he punches Madison? The boys are saying cruel things to him. Maddie and Riley are standing in front of him, lightly touching his shoulders. People are pointing and laughing at the boys. They're not, Maddie and Riley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Maddie and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do, just walk away. Instead, he takes out his knife and punches Madison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nikolai essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. Your jury instructions talk about provocation. And how that affects self-defense. A person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or great bodily harm. Remember, Nikolai ran up on these boys who were tubing away. They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel." I'm going to play that for you so you can hear it. All right, this is at 1:05 in the video. I'm ready.
Go! Kids, go! 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 Kids, go! 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 Kids, go! Go! Doesn't matter.
You didn't. You can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking his snorkel, which was a lie. And he had just ran up on the boys. So, after he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. Defense has zero reasonable argument, especially when it comes to Tony, Riley, Isaac, and Dante. Nikolai gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nikolai pops right up and disembowels AJ. After Nikolai goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nikolai down on the ground, Tony walks by Nikolai with his back to Nikolai, yelling, "Get back to Dante." He turns around to tell Nikolai to get away, and Nikolai turns around and stabs him. Nikolai was facing his group with an open path of escape after provoking a reaction. He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you the state has proven beyond a reasonable doubt this was not justified self-defense, and Nikolai knew it. He knew it from the moment he did it. First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believed death or great bodily harm was imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death, or great bodily harm. So, for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died, but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive. What else was Nikolai's intent but to kill when he slices him up like that? He had the knife blade up. That wasn't an accident. He didn't not know. The first thing he does with it is slice up AJ's stomach. Riley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung. Tony blocked one stab, so Nikolai stabbed him again. The one he blocked, you saw the injury, was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart. But for Nikolai missing vital organs, but for medical intervention. Neil claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified, you heard about anytime there's a puncture wound to the torso, the stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nikolai killed Isaac, almost killed AJ. Riley needed emergency surgery. Luckily, but for dumb luck, he missed the vital organs of Dante. But for AJ blocking one strike and missing vital organs, he survived. Nikolai said he had tunnel vision. Can I have the screen? I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. It makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide of Isaac Schumann, Nikolai stabbed him so hard he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the counts. Third element, he did not reasonably believe the force was necessary. That also goes to I'm sorry, that's part of the third element. So how do you know what Nikolai believed? What a reasonable person would believe? That there's only one person on the planet who experienced what Nikolai experienced, saw what he saw, was standing in his place. And what did Nikolai believe? He believed it was unjustified. The very first thing he does is walk away, doesn't run, doesn't tell Ariel or Ernesto anything, doesn't tell them to run. He walks away from his group to the other side of the river, at some point rinses the knife because it wasn't covered in blood, throws the knife onto the bank before walking back to his group, says nothing to his group other than they took my knife, puts on his hat, sunglasses, and shirt, and sits down in his tube. He's the one, as he said in his interview, who says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan one, get away. Slink away with the crowd. That didn't work. Plan two, play dumb. Can you take the screen down, please?
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature's okay in here?
on? Yeah.
Okay.
Somebody, I hear somebody got stabbed, and I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay. All right.
So I don't know. Okay, well,
Did you see anybody injured?
no.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
Calling each other names, but that's, I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know, kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure, they're drunk, kids being kids. That's what he told Sheriff Knudsen, and he's acting like he has no idea what's going on. Clearly not in shock. You can take it down, sorry. Clearly not in shock. Clearly Nikolai knows that was not justified, and he's looking out for Nikolai. Slinking away didn't work. Playing dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nikolai actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock. The use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up. stabbing Isaac directly in the heart. Burial's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison. He touched his knife when running up on before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nikolai did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene of the chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the Startners at 9 p.m., so 5 hours after the incident, about the boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when you clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nikolai was not in fear, he snapped. He was angry and he snapped, and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? Do you know what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. But if you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nikolai's belief versus reasonable person. Here you know, I submit to you, his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety. Element 1, Nikolai endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. The jury instructions define criminally reckless conduct. Creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there of utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims, and he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nikolai did not use, he was not justified in self-defense when he attacked these people. So we'd ask that you answer yes on that question. In the end, what is beyond clear, Nikolai knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schumann, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nikolai, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state asks that you find Nikolai guilty of all charges. Thank you.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05. Please take the jury out.
All rise for the jury.
Did this. They're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1. They got in his face. They screamed at him. They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing, absolutely nothing to them. Then, when that man, Mr. Mew, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Mew acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go, and more importantly, what I think you need to think about when you are back there thinking about the evidence, okay? First is the law. 1, there is no duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs. Okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Mew. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Joanne Cockfield. The video perspective that the jury is required to consider it is as Nick Mew is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen. That is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Mew doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So, the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Mew, calling him a raper. I'm not talking about that one. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Mew, right? I think to a person, they testified, yeah, we were really concerned about Mr. Mew. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Mew had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Juwan Cockfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Juwan Cockfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or, an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the internet? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Mew's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it, they don't say anything about Nick Mew telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator did testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you, no, they never mentioned that to me. What are the odds? What are the odds that that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife. He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell tell me that makes sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that, Nick said that. They find Ariel's phone in the river, so we know that. We know that Nick comes up to the teenager's tubes, and we know that Cockfield's looking for a phone, and Cockfield's holding a phone. Joanne Cockfield's holding a phone. We know that Nick Mew walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk to her. And what we know is you can see his thumb. He's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable, so he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him. Again, he tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Mew, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they're all blamed. They didn't know it, but the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name, they're just like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does...
Judge, I can't see the exhibits and I'm doing rebuttals.
And step up and move over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Mew's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
What is he on? Whoa! 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 Get away! Oh God! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all homie? He's on camera. Tripping. 4K. He's on 4K. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this? Go! It doesn't matter. He said he was looking for little girls! He said he was looking for little girls! You're looking for little girls? Yeah! That's exactly what he said! Weirding us out! I even have that part on camera, did I? Some young ass kid! What the hell is this guy's problem, bro? We're trying to have fun. Is he gonna claim you? He's gonna claim you! We don't want this motherfucker! Get it on camera! Get it on camera! Get it on camera! Oh God! Oh God, it on camera! Oh God, it on camera!
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Mew has testified that he raises his arm to get her out of his space. That people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, You heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Joanne Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it sat there. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Mew pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite download extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people and whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay? Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Mew's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drug teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Mew committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark. Okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Mew. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people getting injured. Because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Mew's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe. Okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds. We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Mew was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Mew was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Mew's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Mew. Nick Mew's tail down in the water. Presumably he's telling it to the people who are beating him. Right? That's what we know.
He ain't a woman! He ain't a woman! You ain't a woman!
Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Mew's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet, backwards into the water, by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Mew while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that A.J. Martin, who says he's the peacekeeper, that's what he said, he runs up from behind and shoves Nick Mew while Dante Carlson comes in for thirds and smacks Nick Mew in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man, who had heart surgery, is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what A.J. Martin said in his testimony, when he was shown the picture of him making contact with Mr. Mew before Mr. Mew stabbed him, he said, he got me before I got him, I guess. What does that tell you about what A.J. Martin's intention is? He's back in the water now for a third time after getting pushed down by A.J. Martin. And what do we see next? That's Anthony Carlson. He walks right by Mew. Mew doesn't do a thing to him. Mr. Mew doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Mew has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him We know that. And then we know 1 second later that Isaac Schumann comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Mew. And why does it matter? Why does any of that matter? Because if you find the following: Nick Mew is not guilty of all the charges, okay? If you find that Nick Mew believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs. Okay? If he believed the amount of force that he used was necessary to terminate that interference. Okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people. I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nick Mew puts his hand in his head and says something like, my life is over. And Brandy Hart says, I don't know about that. There's self-defense. She says, I don't know what I would have done. But I can tell you I would have been scared shitless. She's been a police officer for 25 years. And that is her response. The state never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peloquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schumann, and you have to find him for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Mew's mental purpose is to kill Isaac Schumann? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him, he didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schumann? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges, with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Mew wanted to get Isaac Schumann away from him. He didn't chase Isaac Schumann down. He didn't move toward Isaac Schumann. Isaac Schumann moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor. Okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard D.A. Anderson say, but for medical intervention, some of these people would have died. Well, A.J. Martin would have. Dante Carlson had a hernia. He repaired a hernia. I'm sorry, the medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from that. And Riley Madison could have got an infection, they said. And I understand that. But if he wanted to kill them, why didn't he? If you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time if he wants to kill him? Why doesn't he slash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Mew believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was no outside extraneous factor, they also say might not be attempts take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video, because I think it's appropriate, that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What he and what Lieutenant Hart said is he's never wavered on is that this was self-defense, that he was fearful, and that he was being attacked. Okay? That he's never wavered on that. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong, some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is. Right? What has persevered through this case is Nick Mew's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin. That has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schuman's family. I have a 19-year-old son. He would be in Isaac Schuman's grave right now. Everyone feels sympathy for Isaac Schuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly, in terms of the burden of proof and what the state has to do, is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, and you say, I need a break, I need to figure this out, that's reasonable doubt. Okay? It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty. because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick, you and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Mew home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
As you just heard Mr. Tropsy say, his entire defense is based on what Nick Mew told you during his testimony was thoughts in his head, the beliefs in his head. What do we know about Nick Mew? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth, practically since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself he's a liar. All right? He did not just not lie about the knife. He lied about all kinds of crazy things. Bizarre things. Why would he say that these boys pulled his pants down? What a bizarre lie to make up. Right? Why would he say that two boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say one boy pulled a knife, that would be good, but if it's two, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible? That he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Mew ran up on these boys. Why he grabbed their tubes. Why he was groping around where their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Mew's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Madison Cohen getting in his face, so to speak.
State of Wisconsin.
And eventually, he did just snap.
Appearances are the same. Attorney Galloway, as a standby counsel, is also in the courtroom. The court made just a few minor changes to the final jury instructions. Those all had to do with spacing and so there were no substantive changes. So there were no substantive changes. My plan is to provide 12 copies of the jury instructions to the jury. I figure having all of them with their own copy on this case might be a good idea. And the verdict forms, Madam Clerk, did you submit the previous verdict forms to the parties? Okay. I do have four verdict forms here. They read verdict as to count 1, then there's the not guilty and guilty, and verdict as to count 2, not guilty and guilty. So if either party wants to see those verdicts, they are welcome to, but otherwise the language mirrors what's in the jury instructions. I advised the parties just before we called the case that they are welcome to stand at council table. I offered a lapel mic to the state, which I believe they're going to utilize. Mr. Lychwick, you can decline the lapel mic if you want. I just want to make sure that my court reporter can hear you during your closing and make sure that the microphone picks you up. I really don't doubt that the microphone's going to continue to pick you up as long as the microphone's down on your table where it is right now and that you don't cover it with papers or anything like that. It should be fine. Anything else we need to take up before we bring the jury in? Attorney Thompson?
No, thank you.
Mr. Lychwick?
No, Your Honor.
Okay, let's bring the jury in.
All rise for the jury.
Thank you. You may be seated.
Ladies and gentlemen of the jury, I'll note that you all have entered the courtroom without your note-taking materials because the evidence portion of the case is over. We're now at the instruction phase where I'm going to instruct you on the principles of law to guide you in your deliberations. Unlike the opening instructions, these ones will be provided to you for reference for your deliberations. In fact, I'm going to print off 12 copies of these so that each of you will have your own copy of the jury instructions. Despite the fact that you're going to be receiving a copy of these, I do urge that you pay close attention to the instructions of the law that I give you now, because they will help guide you as you listen to closing arguments as well. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts and the law. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of this information in this case charges that the above-named defendant, on or about April 14th, 2024, in the area of 1512 East North Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Carlos Maldonado with intent to kill that person, contrary to Wisconsin Statute 940.01 sub 1 sub A. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The second count of the information charges that the above-named defendant, between April 14th, 2024 and October 30th, 2024, in the area of 1512 East North Street in the city of Waukesha, Waukesha County, Wisconsin, did hide a corpse with the intent to conceal a crime, contrary to Wisconsin Statute Section 940.11 sub 2. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. Standby counsel has been appointed by the court to assist with the efficient operation of the trial. The defendant, though, is still representing himself. The defendant has appeared at times in court wearing orange clothing. You must not infer anything from this. This must not influence your verdict in any manner. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant caused the death of Carlos Maldonado. Cause means that the defendant's act was a substantial factor in producing the death. Element number two, the defendant acted with the intent to kill Carlos Maldonado. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Carlos Maldonado with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Hiding or burying a corpse. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant hid a corpse. Element number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with a purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not establish evidence of guilt by itself. You should give it the weight you believe it deserves under all of the circumstances. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial, and whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement deserves. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. The court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence. An exhibit becomes evidence only when it is received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of the parties, the court is not indicating any opinion about the evidence. You, the jurors, are the sole judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the court itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony and remarks to be stricken. Disregard all stricken testimony. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining what the credibility of each witness and the weight you give to the testimony of each witness, consider the following factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason for giving the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. Ordinarily, a witness may testify only about facts. However, in this case, witnesses were allowed to give opinions based on their experiences. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. We will now hear the closing arguments of the parties. Because the state bears the burden of proof in this case, the state is allowed to go first and also make a rebuttal closing if they so choose. Attorney Thompson, you may proceed.
Thank you, Judge. Oh, wow, that's really loud. Okay, good afternoon, everyone. Thank you so much for your patience over these last few days. There's been a lot presented to you, and you are here to perform your civic duty, and we very much appreciate it. We're here this week because of Carlos Maldonado, and we're here to find out and prove to you who killed him. And now at the close of our case, the state has proven to you that Mr. Maldonado was killed by Mr. Lychwick, the defendant. As you heard from the court, the two elements of first-degree intentional homicide are that the defendant caused the death of Mr. Maldonado and he acted with intent to kill him. We also have an intent element in the second charge of hiding a corpse. So instead of repeating the evidence for both charges, my intent here with closings is to argue how all of these pieces fit together for both charges. First, when we consider intent, as the court said, you can't look into a person's mind, and that's fine. So what do we have here in front of us? Operation Slop Shop. We have dates on exhibit number 146, and it says targets identified. It goes back to November of 2023, and interestingly enough, when we look at those autofill sections on Mr. Lychwick's cell phone, that's when you start seeing Mr. Maldonado's name. And those autofills don't just happen. That is the user who has to manually input those names, and then the phone remembers it. Then we have him on exhibit 146 as the target of the first operation. And the numbering of all four of these operations is very important because when you look at exhibit 147, which is Operation Starling, it says at the bottom, the operation can commence since Operation Slop Shop is completed. Funds and reparations have been seized from Slop Shop, so for Starling, and all threats from the first operation have been neutralized. That first operation is Carlos. Now, how do we know that this note was written by Mr. Lychwick? When we look at all of the pieces surrounding this note, and even some of the context and additional items in there, we know that it belongs to Mr. Lychwick. So number one, it's found in his apartment. That's a really good place to start. He lives alone. He references his brother and his mother. He is next door neighbors with Mr. Maldonado. And think about all those German references. Absolutely fine to enjoy German history, to want to go visit it. That in and of itself is not criminal. But the whole point of playing those clips and showing you those conversations is to provide context and show that these notes belong to Mr. Lychwick and they were written by him. There's another name in Exhibit 146 that we have referenced several times of Raven. The sole reason that the state provided the information and the phone searches and the Google returns about Raven is to connect Mr. Lychwick again to these notes. That is the sole reason. When we look at intent to kill and intent to conceal a body, we're also looking at the medical evidence here. And we heard Dr. Scheel talk all about how they processed this scene, how they brought Mr. Maldonado back, and why they did those x-rays. And her words were very specific. When we have a concealed body, we need to be careful on how we process and examine. And when they do those first set of x-rays, that's when we see the two projectiles, which we'll talk about in a little bit. But Dr. Scheel determined that the cause and manner of death was homicidal violence by the two gunshot wounds, and his manner of death was homicide. We may not know how far away Mr. Lychwick was standing from Mr. Maldonado when he shot him. We may not know which gunshot wound came first. But what we do know is that is the epitome of intent to kill. Because that is 2 times you have to pull that trigger. 2 deliberate times. And when we consider the trajectory that Dr. Scheel and Dr. Truesdale talked about when they used that probe, both trajectories of those gunshot wounds were in the right, up, and out the left. Almost as if they came in quick succession to have such a close trajectory to each other. Regardless, though, that's 2 times. We also have evidence that these gunshot wounds are front to back. So Mr. Lychwick is standing right in front of Mr. Maldonado. And let's not forget about the fact that Mr. Maldonado was shot in the face. That is deeply personal. That is intent. That is, I am removing this human being from this earth. That is the target. And that is a surefire way to kill someone by shooting them right in the face. We also heard from Dr. Truesdale about how there were other fracture lines on Mr. Maldonado's skull. And she talked about how that comes from the energy of the bullet, and all that energy needs somewhere to go. When we talk about then how all the threats are neutralized, if that's not intent, I don't know what is. We also then consider the phone searches from Mr. Lychwick's cell phone that we recovered during the search warrant on November 26th. What's interesting here, and what kind of overlaps with the trail camera videos, is that search on April 21st of 2024, 7 days after Mr. Maldonado was murdered, and about 10 days before we see him on that trail cam. He's searching for carcass removal, disposal, how to dispose of spoiled food safely. Sure, it could be innocuous, I guess, but not when you consider everything in the totality. That timing is just too specific. The nature of those searches, the carcass, he's referring to Mr. Maldonado. That's what this evidence shows. Because at that point, he has Mr. Maldonado up on top of that hill in the area in which Moxie gave her trained final response. But this is an apartment complex. This is land that's shared by everybody. And eventually, he'll probably be discovered. And so now, a week later, we have this search of how to get rid of a carcass. And remember that DNR article had 3 options. You can either take it to a landfill, you can take it back to where the harvest originally occurred, or you can bury it. Mr. Lychwick goes a little bit out of order, but it does make sense when you think about the timeline that we've presented to you. So first, we have him on those trail cameras then, 10 days later, with all of his gear. He's got his shovel, he's got his boots, he's got the plastic sheeting, he's got that black packaging with him that looks very, very similar to all of these black garbage bags. And he is up there for 30 minutes where we don't see him anymore, from 12:41 a.m. to 1:10 a.m. And when we see the direction that he's walking, it's exactly the direction up that hill. Because then when you go off camera, you continue going up the hill, or you can divert to that footpath where we eventually found Mr. Maldonado. And there was a lot of talk about something on Mr. Lychwick's hip in that video. Detective Stern said, "I can't tell for sure what that is." And Mr. Lychwick posited that it is a flashlight. Let's go with that. Let's say it is a flashlight. It makes sense in a way, because as you're up there on the top of that clearing, knowing, okay, the DNR suggests that I need to bury a carcass, so I'm going to try digging and I'm going to bring my shovel out there. There's no lights up there. So of course you need a flashlight to see where you're digging. But then he realizes this isn't going to work. And as Detective Stern talked about, the dirt up there, you can get down a little bit, but then eventually you're hitting clay, you're hitting something harder. And that shovel that we have is not something that's going to be able to break through that. He can't bury Carlos deep enough to avoid detection. So then what does he do? Landfill. That's what we're going to do with this. So he starts dragging him down, because it's a lot easier to go down that hill than it is to go up that hill. So between that and Moxie hitting up there, that's where this all started. So then as he decides, I need to get rid of Mr. Maldonado, I need to get him off of this property, he has him in these opaque black garbage bags, which we saw from the Google returns. He's got the tarp as well, which helps him drag or slide Mr. Maldonado down the hill to this footpath. The ropes, when you look at those ropes that were tied to the chair in Mr. Lychwick's apartment, and you put them side by side with those ropes recovered from Mr. Maldonado at autopsy, look at those patterns. Look and make that comparison, because those are the same kinds of ropes. Because he used what he had. And so even those knots, if you look at how those knots are on each of those 4 ropes, they look pretty close to those photos of the ropes from his apartment. And when we talk about intent to conceal, he's even threading those ropes through the grommets on the tarp. We have tape on Mr. Maldonado's hands. We have that black duct tape that is used to enclose Mr. Maldonado to tie together or tape together those black plastic garbage bags. And then once he is in this footpath, and we saw a picture of Carlos, he's not a small guy. And so if it's too difficult to get him into a car to bring him to a landfill, I can't drag him back up the hill now, so he's going to have to stay here. And so then we start piling on all of those branches, all that debris, and he goes undetected. Family knows that Carlos isn't here, that he's missing, but nobody sees him anymore. After Home Depot on April 14th, we see from his phone records he comes back to 1512 East North, and then nothing. There's no movement. Nobody sees him again. That combined with what he's wearing on that Home Depot video, and that's what he's wearing when we find his remains, this all goes to establishing April 14th. And even going back to those trail cams, yes, we have that half-hour break, but we never see Mr. Lychwick come back with any of his tools or his gear until 4:39 a.m. that morning. He goes back and forth. We see him go to the garage. We see him walking back up in that direction. So that's 4 hours where he's out there and he's not exercising. That just doesn't make any sense compared to what we saw him bringing out there. So then we talked a lot about the search of Mr. Lychwick's vehicle. And before we get to that point, though, he goes to U-Haul. And that is out of the ordinary for what the detectives have been seeing in terms of his pattern of travel over the last few days. So as he starts traveling north, we follow him to a storage facility that he has no history of searching for until within 48 hours of us finding Mr. Maldonado. He had rented it, according to that receipt, on November 1st, gets that free month promotion, and now he's got to empty everything out because that month is, maybe he's moving it. Maybe he's going to another storage unit. I don't know. But what we know is he emptied it. And then we follow him. And we saw him on the surveillance emptying it. So we follow him back to Waukesha. Officers stop the car. They seize the car. There's nobody else in the car with him. And what do we find after we get a warrant to search his car? The murder weapon. Inside that trunk, we find the shovel. In the back passenger seat, we have boots. We have numerous boxes of 9mm ammunition. So for Mr. Lychwick to say, I've never seen that gun before, I don't know what it is, I don't know how it got there. You certainly have a lot of ammunition for a 9mm. So then we also find all these garbage bags. We start putting all of these pieces together here. What's important to know, and really I'll sum up Ms. Crawford's testimony. She told us all about firearms identification and how we have those striations and those grooves and the manufacturing characteristics versus the individual characteristics. But here's the bottom line. These two projectiles recovered from Mr. Maldonado's body were fired from this gun, period, end of story. So now you have an individual who is targeting the victim. He has his name written in notes. He is up in a trail area at the top of the hill. He is hiding evidence related to a homicide. And you heard on that recording, they were tearing up everyone's apartments and I had to get my war bags out of there. Your war bags with the murder weapon? Thank you very much. So now we have this, and Ms. Crawford says, yep, this is the murder weapon. Now we go and arrest Mr. Lychwick. We get his buccal swab, which you've heard a lot about. And this is another reason why this whole theory of, I've never seen this gun before, I don't know anything about it. His DNA is all over that gun. When we heard from Ms. Taylor, we talked about the swabs from the grip of the Luger, and it's, in the state's view, important because this is a single source profile. There is no mixture. There is nobody else's DNA from the swab of the grip of this Luger. And it's Mr. Lychwick. And you heard Ms. Taylor talk about how in order to find another profile, or it would take us testing a quadrillion people to see a similar profile. There are not a quadrillion number of people in the world. So there's no question that Mr. Lychwick's DNA is on the grip of this Luger. Then we also look at the towels and the rubber bands. The exterior towel is a mixture, but we have very strong support for inclusion, which is the highest reporting level that our state crime lab has. We also see that quadrillion number again. And then we get to the interior towel, which is back to a single source profile. And it's Mr. Lychwick's. So ladies and gentlemen, sometimes, and you heard Mr. Lychwick talking about it, objecting to it, sometimes little things, they might seem, well, everyone has bleach. Everyone shops for hand soap. Everyone shops for garbage bags. True. I don't dispute that at all. But you can't take everything and just look at it individually in a vacuum. Your role here is to search for the truth, not to search for doubt. And the truth is that on April 14th of 2024, Mr. Lychwick murdered Mr. Maldonado. And all of the evidence is right here in front of you. And so I'm asking you, when you go back there to deliberate, that you hold Mr. Lychwick accountable and you find him guilty on both counts. Thank you.
Thank you, Attorney Thompson. Mr. Lychwick, you may give your closing argument. You may stand at council table if you would like, and you can also use the lapel microphone if you want.
I think this microphone will suffice, Your Honor.
Go ahead then.
Ladies and gentlemen of the jury, thank you for coming and giving your precious time and effort to this case. I ask you now to do what you must do to acquit me of these horrible charges. I am totally innocent of this crime. I did not know this man well enough to hurt him. He did not know me well enough to have attempted to hurt me in any way. We were neighbors, but we did not know each other. The defense argues that I went on top of the hill. They take broad liberties with the truth and with their idea of facts in this case. But the fact is they have no proof that I was ever even on top of that hill. I have established that I have a right to be out in my own yard and do whatever I do. They have no proof that I even spent all the time they're saying I did on the night in question when they're insinuating that I had something to do with the handling of poor Mr. Maldonado. They don't know that I went home and that I was on a hike looking around for possums that lived in my yard and feeding my rabbits because I couldn't sleep that night, that I normally would put my tools down and go for a run up and down the hill or a quick trip to buy groceries at all hours of the day. During the daylight hours, I use a jogging suit. At night, if I'm out in my
I'm going to object at this point. This is all testimony and none of these facts are in evidence.
That's sustained. Mr. Lychwick, I caution you, you can argue inferences and argue what the state doesn't show in their evidence, but you can't testify about matters that have not been testified about. So just be careful that you're not trying to introduce new evidence or testify in any way. You can continue.
Ladies and gentlemen of the jury, as you were instructed to do so, I implore you, if you have any doubts in this matter, to find me not guilty. There are plenty of doubts in this case and what the prosecution has established as their case against me. The accusers, the Waukesha Police Department, headed by the investigative team of Detectives Benjamin Stern here. I implore you to weigh in consideration of my innocence in this matter and to take into consideration the manner in which they executed their search warrant against me. The search warrant being established originally because one of their detectives asked me, I think this has been established as evidence already, asked me about the presence of plastic bags in front of my car, in which I truthfully answered the detective, telling the detective that I moved my shovel and everything into my car for winter.
I'm going to object. None of this is in evidence.
It has to be.
It's sustained. It's sustained. It's not in the trial record. The jury has not heard any evidence of this, and the legality of the search warrants and the manner of their execution is not an issue for the jury to determine. You can continue, Mr. Lychwick.
If I may, ladies and gentlemen of the jury, I have been unable to present a hearty defense in this matter because I have been imprisoned in the Waukesha County Jail for 18 months now and isolated from my funds and my family and my friends and my ability to hire an attorney.
Okay, Mr. Lychwick, stop, please. Again, these are not matters for the jury to consider. They are to consider only the facts and evidence that was presented in the case, not what could have been, not what wasn't, only the facts and evidence that have been presented. Your status during the pendency of this case is not relevant and should not be matters for the jury to know.
But
you introduced it, but it should not be for them to know. So focus on the issues here and the evidence that has been received in the trial this week, and you can continue your arguments.
Your Honor, you noted these protests throughout the trial.
I have. Now continue.
Ladies and gentlemen of the jury, I implore you again, if you have any doubts as to my guilt, please find me innocent. I have a life out there. I am a good man. I am a God-fearing Christian. I just want to go home. I want to resume my life. And when I go home, the Waukesha Police Department and anyone assisting them will be able to continue searching for the actual killer or killers of the poor victim in this matter. As long as I am in custody, they have stopped looking for who actually killed this man. Imagine that whoever did this is still on the street. I implore you to please send me home. Find me not guilty in this matter because I am not guilty in this matter. And owing to the corruptibility of people and human nature, I am telling you there is a corrupt element within our local Waukesha Police Department. And if you find me innocent, perhaps there will be some house cleaning and they can take care of it. Somebody will investigate this matter and we will all be a little safer. I thank you for your time in coming here again. And again, my final statement to you is, if you have any doubts in this matter, if you have any doubts about my guilt, please find me not guilty.
Thank you,
I
Mr.
rest my
Lychwick.
case.
Any rebuttal closing, Attorney Thompson?
Very briefly.
Go ahead.
What I'd like to posit to the jury is there's probably someone else who really wants to go home or wanted to go back to his apartment that night.
I object, Your Honor. She's already had her chance to make her statement in this matter.
The objection is overruled because the state bears the burden of proof in this case. It is allowed by law to give a closing argument and provide a rebuttal closing. So the state gets the last word. Attorney Thompson, you may continue.
Thank you. Mr. Maldonado had plans with his daughter, and she never anticipated that he wasn't coming back to his apartment that night. And so who's responsible for that? Mr. Lychwick. So let's all remember why we are here. Because Mr. Lychwick murdered Mr. Maldonado. And that's what this evidence shows. And the law that the judge read you is not, if you have any doubt, you're not searching for doubt. You search for the truth. And the standard is not beyond all doubt. It is beyond.
Objection, Your Honor. She's trying to instruct the jury to find me guilty.
I disagree, Mr. Lychwick. The state is reciting elements of the reasonable doubt instruction. That's permissible. And ultimately, ladies and gentlemen, you are bound to follow the law and the instructions I give you, not the law and the instructions the attorneys may interpret or recite. Ultimately, what's in the jury instructions is what you follow. Attorney Thompson, you may continue.
Thank you. As I said, it's not any doubt. It's not even beyond all doubt. It is beyond a reasonable doubt. When you look at all of these pieces together, just like Dr. Truesdale said, the bones tell a story. They tell a story about someone's life. And all of these pieces of evidence here tell us the story of how Mr. Lychwick murdered Mr. Maldonado and then hid his body so that nobody would find him and hopefully he would get away with what he did. So I'm asking you to find him guilty on both counts. Thank you.
Thank you. Now, members of the jury, the duties of the parties in the court have been performed. This case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 4 forms of verdict will be submitted to you concerning the charges against the defendant, Kevin Lychwick. As to count 1, one verdict reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, 2 verdicts. One reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of hiding a corpse as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of hiding a corpse as charged in count 2 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case, and therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any question in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. We will first swear the officer and then strike the alternates.
Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them, or you speak to them yourself, except to ask whether they have agreed on the verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. So help you God.
I do. Ladies and gentlemen, there are 14 of you, and we can only allow 12 to go back and deliberate on this case, which means we must strike 2 jurors at this time from the jury pool. Those alternates are picked by random. It's probably disappointing if you get selected as an alternate because you've sat through all of this trial and you can't participate. But understand that we pick alternates the way we do just to guarantee that if any emergency comes up or we lose a juror for a family emergency or a medical situation, that we can continue the trial. So we build in a little bit of a buffer to allow for that to happen, especially on multi-day trials. So I have the list here with the alternates. If I read your name as an alternate, I ask that you stand, please. The alternate jurors are Paige Hornack and Nancy Kovacs. Okay, what we're going to do is our jury bailiff will escort you back to the jury room to get any belongings that you may have back there. I'm going to ask the other jurors to remain where they are for now. We'll have those jurors go collect their materials, then they can be released. And once that's done, we'll have the other jurors retire to the jury room.
There is, you can wait, I can get it to her. Thank you.
I'm now providing a copy of the verdict forms and 12 copies of the jury instructions to the jury bailiff, and the jury may now retire and begin their deliberations.
All rise for the jury.
Thank you. You may be seated. We are now outside the presence of the jury. If the jury requests any of the photographs that were used and published, my inclination would be to provide those to the jury without calling the parties back to go through each one that they've selected. Mr. Lychwick, I recognize that you've objected to a number of the exhibits being introduced. The exhibits that have been introduced and already used with the jury I would send those back if they request. Do you have any issue with that process?
I certainly do, Your Honor. Especially if I entered a prior objection to them.
And your objection would still be noted to those exhibits, but my point is that they've already been shown to the jury. So if the jury asks a question, I would have to bring you back into the courtroom. I'd have to bring the state's attorneys back. We would confer about the question, provide an answer to the jury. Sometimes that takes a little bit of time, and that's what we will do for ordinary questions. Other times the jury says, hey, could I see exhibits 120 through 130? If those are all photographs that have already been displayed to the jury on the screen, I'm not going to bring the parties back and talk about whether or not those should go back to the jury because they've already been displayed in court. The jury has already seen those. They're just asking to see them again. For photographs, I'm just going to send those back to the jury. For other things where parts of them may have been published, for example, some of the reports were published but not in their entirety, I would not be sending those back automatically. We could discuss that. But I'm just talking about just regular pictures, one-page picture files. If the jury asks for those, I'm going to send them back without bringing the parties in to talk about that if they've already been published. Understand?
I think so, Your Honor.
Okay, that's fine. And I was going to go to the state. Attorney Thompson, that's fine with you?
Yes, I'm sorry.
That's fine. If there's anything else where I see they've requested another exhibit that may have been published in part or something other than just a simple photo, I'll call the parties back. Then with the issue of the videos, if they request to see any of the videos, we do have the capability of streaming the videos directly back into the jury room. We can either do it one of two ways. We can stream it back in the jury room, or we can bring them back into court and play it again on these monitors. I'm going to decide to stream the videos into the jury room. The way we do that is we have one of our bailiffs go back to verify that the streaming and the live feed is live. We will play the videos twice, and then that'll be the extent of how they're played back. Because we can't just send a thumb drive and the videos back to the jury and let them poke around with the videos. We have to control the playback. So that would be the process for the videos. If there's any other questions or any other exhibits that they want to see that don't meet those, well, sorry, let me just be clear. If we live stream the videos, I'm calling the parties back and we'll reconvene. We'll do it on the record. We just won't have the jury brought in. But otherwise, simple request to see the photographs. I'm not going to bring the parties back to do that. Anything else from the state then before we wait for deliberations?
No, thank you.
Anything else from you, Mr. Lychwick?
Well, thank you, Your Honor.
Okay. Then the state, please provide some contact information, and we will stand in recess until we have a verdict.
To that.
It's 13 against 1. It's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Mew, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat. Right? And if you think about it, they're all blamed. They didn't know it. But the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does...
Judge, I can't see the exhibits and I'm going to do a rebuttal.
And step up and move over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Mew's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
What is he on? Whoa! 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 Get away! Oh God! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all homie? He's on camera. Tripping. He's on 4K. Yo, the new iPhone got that good quality. What did you say? Yeah, what the hell? Who is this? Yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this? Go! It doesn't matter. He said he was looking for little girl! He said he was looking for little girl! You're looking for little Yeah. That's exactly what he said. Weirding us out. I even have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? We trying to have fun. Is he gonna claim you? He's gonna claim you. We don't want this motherfucker. Let it on camera. Let it on camera. He on camera. Oh God. Oh God. He on camera. Oh God. He on camera.
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Mew has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Juwan Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it sat there. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Mew pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a cell-blade download extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people and whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay? Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Mew's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drug teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Mew committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark. Okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Mew. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people getting injured. Because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Mew's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Mew was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Mew was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Mew's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, "Stop, stop, stop." He's not yelling it to Nick Mew. Nick Mew's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know.
He ain't a woman! He ain't a woman! You ain't a woman!
Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Mew's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet, backwards into the water, by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Mew while he's still on his back, kind of on his on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that A.J. Martin, who says he's the peacekeeper, that's what he said, he runs up from behind and shoves Nick Mew while Dante Carlson comes in for thirds and smacks Nick Mew in the face again. I would submit to you at this point, it's coming from all sides, and from multiple people. And this man, who had heart surgery, is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what A.J. Martin said in his testimony, when he was shown the picture of him making contact with Mr. Mew before Mr. Mew stabbed him, he said, he got me before I got him, I guess. What does that tell you about what A.J. Martin's intention is? He's back in the water now for a third time after getting pushed down by A.J. Martin. And what do we see next? That's Anthony Carlson. He walks right by Mew. Mew doesn't do a thing to him. Mr. Mew doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Mew has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Schumann comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Mew. And why does it matter? Why does any of that matter? Because if you find the following: Nick Mew is not guilty of all the charges. Okay? If you find that Nick Mew believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs. Okay? If he believed the amount of force that he used was necessary to terminate that interference. Okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who, you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people. I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nick Mew puts his hand in his head and says something like, my life is over. And Brandy Hart says, I don't know about that. They're self-defense. She says, I don't know what I would have done. But I can tell you I would have been scared shitless. She's been a police officer for 25 years. And that is her response. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peliquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schumann, and you have to find them for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Mew's mental purpose is to kill Isaac Schumann? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schumann? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges, with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Mew wanted to get Isaac Schumann away from him. He didn't chase Isaac Schumann down. He didn't move toward Isaac Schumann. Isaac Schumann moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor. Okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard DA Anderson say, but for medical intervention, some of these people would have died. Well, A.J. Martin would have. Dante Carlson had a hernia. He repaired a hernia. I'm sorry, the medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from that. And Riley Madison could have got an infection, they said. And I understand that. But if he wanted to kill them, why didn't he? If you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him 1 time if he wants to kill him? Why doesn't he smash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Mew believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was no outside extraneous factor, they also say, might not be attempts, take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video, because I think it's appropriate, that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What Lieutenant Hart said is, he's never wavered on, is that this was self-defense. That he was fearful and that he was being attacked. Okay? That he's never wavered on that. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong, some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is. Right? What has persevered through this case is Nick Mew's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin. That has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schuman's family. I have a 19-year-old son. He would be in Isaac Schuman's grave right now. Everyone feels sympathy for Isaac Schuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly, in terms of the burden of proof and what the state has to do, is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, and you say, I need a break, I need to figure this out, that's reasonable doubt. Okay? It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty. Because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick, you and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Mew home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
As you just heard Mr. Tropsy say, his entire defense is based on what Nick Mew told you during his testimony was thoughts in his head, the beliefs in his head. What do we know about Nick Mew? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth, practically since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself. He's a liar.
Thank you. You may be seated. I have been advised that the jury has a verdict. Is that correct? Is Mr. Murdah the jury foreperson?
Yes.
Okay. Could you please hand the folder to the bailiff? The court will now read the verdict. In the matter of State of Wisconsin versus Kevin Lychwick, verdict as to count 1. We, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information, signed and dated this 11th day of June, 2026, and it bears the foreperson's printed name and signature. Verdict as to count 2. We, the jury, find the defendant, Kevin W. Lychwick, guilty of hiding a corpse as charged in count 2 of the information, signed and dated this 11th day of June, 2026, again bearing the foreperson's printed name and signature. The other 2 verdict forms are left blank. Ladies and gentlemen, I am now going to do a process called polling the jury. It's going to ask each of you individually if these are your verdicts. I'm going to start in the back corner. Ma'am, are these your verdicts?
Yes, it is.
Are these your verdicts, sir?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, it is.
Are these your verdicts?
Yes, Your Honor.
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 Are these your verdicts?
Yes.
And are these your verdicts?
Yes, Your Honor.
Is the state satisfied with the polling?
Yes.
Mr. Lychwick?
I don't know what to say at this point.
Okay. The court has polled all individual jurors, and all jurors have indicated that these are their verdicts. Members of the jury, with the verdict delivered, your service in this case has concluded. Therefore, you may now freely discuss the matter with any individual of your choosing, and all of my restrictions on such discussions have been removed. However, it's important for you to understand that you are under no obligation to discuss this case or answer any questions about it unless I require you at some later date to answer questions about it. This applies to interactions with the parties, their attorneys, the members of the media, any other individuals. Should you choose to discuss the case with others, though, I urge you to approach these conversations with the seriousness that they deserve. I would also recommend that any discussions you engage in are ones that you would feel comfortable having in the company of your fellow jurors and openly in court under oath. While you have the right to speak freely about this case, it is important to remember that discussions in the jury room were conducted in an environment designed to be open and free from fear of reprisal or criticism. Your fellow jurors shared their opinions fully and candidly and may not want their opinions made public. Therefore, I urge you, when you discuss the case and discuss deliberations, you discuss those from your own viewpoint and not the viewpoints of your fellow jurors. Finally, ladies and gentlemen, I have a couple of matters to still discuss with the parties. It'll take probably about 5 minutes or so. If any of you have any questions or feedback that you would like to give me, stick around in the jury room and I will come back and do my best to answer those questions if you have any. Otherwise, on behalf of Waukesha County, I extend my deepest gratitude for your service in this case. I recognize that you have devoted considerable time to this case this week, but your contribution is a vital component of our justice system as enshrined in the United States Constitution and our state constitution. So it's my hope that you have found this experience to be rewarding. You are now discharged in this case. Thank you.
All rise for the jury.
Thank you. You may be seated.
We are outside the presence of the jury. Attorney Thompson, any motions from the state?
I would ask that the court enter a judgment of conviction on each count.
Mr. Lychwick, are you moving for judgment of acquittal notwithstanding the verdict?
Yes.
Okay. The court will grant the state's motion and order judgments of conviction as to each count. Mr. Lychwick, I'll advise you that you are a convicted felon now, and as such, you may not use or possess a firearm for the remainder of your life. You also may not vote until your civil rights have been restored. We will schedule this case for sentencing. Attorney Thompson, do you have a specific length of time in mind as to how far out you want to go for sentencing?
I am not requesting a PSI in this case, so at the family's wishes, as soon as the court can accommodate, please.
Mr. Lychwick, there is a mandatory sentence of life imprisonment on count 1. The court does have the ability to determine early release, or eligibility for release, I should say. One of the options you can exercise for sentencing is a request for a pre-sentence investigation. The state's not requesting one. I don't particularly need one, I don't think. But if you would like one, we could order a pre-sentence investigation. Otherwise, I could offer a date as early as tomorrow for sentencing.
I would like a pre-sentence investigation, Your Honor.
Okay. I'll allow for the pre-sentence investigation, so we'll schedule the matter accordingly. That'll go out about 60 days, probably.
Thursday, August 20 at 8:30.
That
Okay.
works for the state. Thank you.
August 20 at 8:30 then. The court will order the PSI. The defendant is remanded into custody. And Attorney Galloway, the court is relieving you of your standby counsel appointment.
Thank you.
Anything else from the state at this time?
No, thank you.
From the defense?
I plan to appeal, Your Honor.
I understand. You will have that right, and I will notify you of your opportunity to appeal after sentencing. We stand adjourned.
all right? He did not just not lie about the knife. He lied about all kinds of crazy things, bizarre things. Why would he say that these boys pulled his pants down? What a bizarre lie to make up, right? Why would he say that 2 boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say 1 boy pulled a knife, that would be good, but if it's 2, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible? That he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Mew ran up on these boys. Why he grabbed their tubes. Why he was groping around where their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Mew's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Madison Cohen getting in his face, so to speak. And eventually, he did just snap. He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the violence before he started it. He felt humiliated, and he wasn't going to let it go. I asked him, did you ever take a step back at any time when she was yelling at you? No. With no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got the 6 teenage boys standing on the side by their tubes. He's confronted by the 2 girls. Everybody else is in the background. He hits Madison Cohen when he's only got 2 girls standing in front of him. After the fight, it's one-on-one to start. It's Dante hitting him, and then arguably 2-on-1 when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Mew continued violence. He chose more violence after that part of the fight was done. Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him telling Dante, his brother, get away, get back. Mr. Mew turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere. That he was attacked from all directions. False narrative. He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right. He keeps talking about how these boys wanted to make a video. Well, they were making a video. But what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on them in their tubes. Nobody laid a hand on him until after he had already stabbed a number of people. Isaac Schumann tried to stop him. He got killed for his efforts. He seems to be arguing, the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people. He calls Maddie Cohen the queen of the river, and he calls her a bully, calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, that it was freaking them out. She tried to protect them. You know, maybe if we had more people on the river trying to protect people, the world would be a better place. They've made, over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Mew, who, as Mr. Trosky said, was lifted off of his feet by the punch from Dante, punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later. We have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling. The fact that they're arguing that Maddie had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face tells a different story. He has expressions of anger. He has expressions of, I guess, humor. He's smiling. He's smirking. Well, after he has his knife out, he clearly feels comfortable. There's no look of terror in his face at any time. A.J. Martin was not armed. He pushed Mr. Mew in the back. We know that. He didn't kick him. He didn't punch him. He didn't hold his head underwater. He pushed him in the back. And for that, he got a incision on his body from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Mew. They made a big deal about Lieutenant Hart telling Mr. Mew in the interview that she would have been scared too. Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened. About having 2 kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too. They're arguing that he had no intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up, severing 2 of Isaac's ribs right into his heart. All right? If he didn't intend to kill him, why not stab him in the belly? Right into his heart. We've heard no explanation whatsoever as to why he stabbed Riley Madison. We know from the video she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't attacking him. They don't explain that because there is no explanation. None. He wasn't in fear for his life from Riley Madison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him. They've talked a little bit about extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks. Putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Riley Madison specifically that Larry and Davis and his brother, we saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, you know, whenever you have an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't get killed. It's not by anything he did. He just got lucky. Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and pulling his pants down and all this other bizarre baloney. He used his intellect, because we know he's smart, to craft this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient to convince people that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No, no, no. You have my full confidence. I know you're going to return a just verdict of guilty and deliver justice to Isaac Schumann and everybody else who got hurt by this man. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Mew is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nikolai Mew. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew not guilty. Return only 1 for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Mew commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question. As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Mew is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
Do you swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict and that they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict that they have agreed upon, so help you God?
I will.
The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, one envelope per count. If you reach a verdict, please put that verdict, signed by the foreperson, back into the envelope. The other forms that you don't use can be discarded, but there only should be one verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you, so we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope. The 2 alternate jurors are Darren. You may.
Evolving over the
Verdicts read as follows. As to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree reckless homicide as submitted. Question, did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 3 of the information, Dante Carlson, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 4 of the information, Anthony Carlson, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 5 of the information, Riley Madison, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. As to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew guilty of battery as charged. Did Mr. Mew commit the crime while using a dangerous weapon? Answer, yes. Members of the jury, I do have to verify that this is in fact a unanimous verdict. So I'm going to ask each of you if I correctly read the verdict and if you agree with it. So when I call your name, if you agree with the verdict that I read, please answer by saying yes. If you disagree with the verdict, you can answer by saying no. Ms. Navarro, do you agree with the verdict that I read?
Yes.
Mr. Cook, do you agree with the verdict that I read?
Yes.
Mr. Snell, do you agree with the verdict that I read?
Yes.
Ms. Pelzel, do you agree with the verdict that I read?
Yes.
Mr. Wiley, do you agree with the verdict that I read?
Yes.
Ms. Knapp, do you agree with the verdict that I read?
Yes.
Mr. Diedrich, do you agree with the verdict that I read?
Yes.
Ms. McMahon, do you agree with the verdict that I read?
Yes.
Mr. Henderlong, do you agree with the verdict that I read?
Yes.
Mr. Ashland, do you agree with the verdict that I read?
Yes.
Ms. McMullen, do you agree with the verdict that I read?
Yes.
Ms. Lewandowski, do you agree with the verdict that I read?
Yes.
Any additional polling? No? All right. It is a unanimous verdict. Members of the jury, your service in this case is completed. You are free to read accounts about this trial. You are free to talk about this case with anyone. However, you do not have to discuss this case with anybody or answer any questions about this case other than from the court. So this includes the parties, the lawyers, the media, or anybody else. If you do decide to discuss this case with anyone, please treat any such discussion with a degree of solemnity, such that whatever you would say, you'd be willing to say in front of your fellow jurors or here in open court. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or the public. For that reason, please respect the privacy of the views of your fellow jurors. If you do decide to speak, please only speak for yourselves and not for anybody else. On behalf of my colleagues, Judges Needham, Vlack, and Nordstrand, along with my courtroom staff, thank you for your participation in this important case. Court is now adjourned. Please take the jury out.
All rise for the jury.
Want to take one moment?
Please be seated. Based on the unanimous verdict, I will enter convictions on each of the 6 counts. Bail is revoked. Mr. Mew will be held in custody pending sentencing. My staff will contact the attorneys and will schedule the sentencing date. I will order a pre-sentence investigation report, but we can do the scheduling at a later time. Is there anything else, Mr. Anderson?
No.
Mr. Schroffesi?
No, sir.
All right. Thank you, everyone. Court is adjourned.
Folks, if anybody on this side of the courtroom could please exit, anybody on this side, please stay.
Get over.
And good morning again. I am Paul Bloom, Fox 9 News, here as we approach 11:15 Central Time in our Fox 9 live streaming center. And that there is the camera going off on your screen. This case now closed. Jury in St. Croix County, Wisconsin, Hudson, Wisconsin there, finding Nikolai Mew guilty. I want to be careful with my verbiage. So he's found guilty up and down the number of counts he was facing for each of his victims there, but found guilty of lesser charges. So he escapes, obviously, for him, the life imprisonment, the top count of first-degree intentional homicide, second-degree intentional homicide, but found guilty there, as you can see on your screen, first-degree reckless homicide. So that charge was what we would call lesser included, a lesser included charge of murder. The judge, Judge Waterman, part of these 30-page jury instructions we've been talking about the last couple days, was to go down the list of charges from the top. So the jury worked through that. They said it was not a first-degree intentional homicide case. They agreed unanimously, clearly. Then they went down to second degree. They look at the verbiage, the law around second-degree intentional homicide, his claims of self-defense. They found him not guilty. The third count underneath that was first-degree reckless homicide, and that is what they are convicting him on the top count. Similar situation, we don't have a full screen to show you, but on the stabbing victims, those who survived, they did not find guilty. They acquitted him on the top counts there of the first and second degree attempted intentional homicide, instead finding him guilty on charges of reckless endangerment, recklessly endangering safety. Marsh Hallberg, criminal defense attorney. Hallberg Criminal Defense has been with us all morning a couple times during this trial. I know we talked about that reckless seemed to be, the sweet spot, if you will, in this case. I'm a bit surprised in the timing, given the jury, it only spent half a day yesterday, the morning today. I thought if they were coming back this quickly, it would be more of a self-defense finding. But maybe we were right. That reckless count, just given the totality of the circumstances out there, they felt that was the most appropriate for Miyu's actions.
I think at the risk of sounding modest, I think we kind of had a pretty good read on this. We watched the whole trial, and they quickly knocked out that intentional homicide. So they must have done that very quickly. Just conceptually said, is there anybody here that thinks he intentionally was trying to kill these people? And they knocked that out quickly, and then were able to focus on the second half. It's kind of interesting. I don't think I missed anything just now, but I'm used to when juries return verdicts, that we read all the counts, and each one is not guilty, not guilty, not guilty. Then you get to the guilties. So here it appears they just only read, in Wisconsin, the guilty forms, and they just presume that the others are not guilty because they didn't address them at all. So big difference. The problem we have is you start to get into some really complicated sentencing issues that are now going to come up because you've got separate victims, and so you get in this concept of same behavioral act. That is, that there was one incident that happened in the river that day within 25 seconds, but there are each one's a separate victim. So you get into the arguments about how the sentences increase because of more than one victim. Do they run concurrent? Do they run consecutive? Are there enhancements that happen, just an aggravating factor of more than one person being hurt? All of those types of things can be considered.
And Marsh, I'm going to cut you off there. I have more questions. I just want to point out now for our streaming viewers and those of our Fox 9 loyal viewers who are watching our 11 a.m. coverage, I am told now we are simulcasting, we are live streaming and broadcasting in both.
All right, so for tomorrow, I don't know what live trials are going to necessarily be played here, but I will definitely do the Valet kid. We'll do him tomorrow. We'll replay that one, certainly tomorrow. And we have the verdict for the trial earlier. He was guilty. The defendant was guilty, and he defended himself. And we replay the Apple River trial, and I was glad to replay that. So that will be. This stream is completed, and we'll do the garden later on, of course, like we usually do. Time. But tomorrow, it'll be in the morning time tomorrow. Yeah. Yeah, time tomorrow. Probably it'll be after the garden live tomorrow. I like to say around I don't know, but maybe 8 o'clock or later, maybe 9. I will. All right, Alien, have a good one. Okay, so Moki says the Rose Petal trial is interesting too. Okay, I will add that one to the one to play after the Valet trial. Okay, thank you, Moki, for that one. And we have a couple of different. I like the different trial requests. They're good to have. And See you in the garden. And Saul, I will update you about a time. If the time changes, I'll update you. Okay. All right, everybody. Thank you all for coming, and have a good evening. An afternoon. Good afternoon to all of you. Okay. Also, thank you, Moki, for that suggestion. Thanks for helping out with the trial stream. Same thing with everyone else too.